Your Lordship.
Hmm.
Lordship, I beg to mention that for listing an RSA matter,
Why?
there is an urgency, my lord.
What is the urgency?
My lord,
What's the urgency?
that my senior has advised me to.
A senior cannot ask you like this. Senior has to also tell you what is the urgency about. Hmm. Then what to do?
My lordship may kindly list the matter on this Monday, 25.
Why? Give me a good reason for that. I do one thing. I will give you an opportunity to again mention
Yes,
at 2 o'clock after getting the due information from your senior.
yes, my lordship. Obliged.
Yes, what is this?
Lord, it is against demand by the learned trial court, by the learned lower appellate court to the trial court, my lord. Under Order 41, Rule 26,
Your ex parte decree.
ex parte decree.
You had a
Plaintiff.
yes. What is wrong? Nothing is wrong.
Only, my lord,
There's nothing wrong. No, absolutely right.
in the this case, my lord, this injunction case, they appeared, they received the notice in connection with that.
Maybe.
And now they are saying that they have not received.
But then also,
But
you see, the reason why it has to be done is on the basis that the summons of service of summons was not duly served. Without hanging,
it was by hanging. It was by, when refused, it was by hanging, someone was served.
Hmm?
By hanging, someone was served.
no, the summons was not served.
That is the wrong finding. it was, someone was served by hanging.
And how many witnesses were there? How many witnesses? For summon,
Or two witnesses. is
two
required.
witnesses has to be there. Whether
Yes.
two witnesses were there.
That finding is not accepted. Whatever it is, my lord, but the finding which has been recorded by the lower appellate court that it was not served, this is the wrong finding.
That is a grievance, not a ground of objection.
But it was by hanging. I have gone through the record.
It's okay. But whether it was done so in terms of the Rule 64, no. This is an appeal under Order 43, Rule 1T. 1T,
One you,
1U
one you.
of the Code of Civil Procedure, challenging the order dated 12/2/2007, passed by the learned Court of the Additional District Judge Kachar in title appeal number 4/2004, whereby the appeal whereby the learned First Appellate Court remanded the suit back to the trial court in exercise of the powers under Order 41, Rule 23A of the court. From the facts necessary, from the facts which are necessary for adjudication of the instant appeal, it transpired that the suit proceeded ex parte against both the defendants on the basis of an order dated 29/1/2004, whereby the learned trial court accepted the summons served upon the defendants and thereupon proceeded to decide the suit ex parte. The learned First Appellate Court, while taking note of the materials on record, had come to a finding that the summons upon the upon the appellant, who was the defendant number one, was not served in the manner envisaged under law. And taking into account that the service of the summons was not properly served, which would require the suit was remanded back to the learned trial court with a direction to dispose of the suit within 3 months after giving chance to the defendant number one to file the written statement. This court had duly perused the records and is of the opinion that the said order passed by the learned First Appellate Court dated 12/2/2007 does not call for any interference and as such, the instant appeal stands dismissed. This court taking into account there was no stay.
There was
taking into account that there was a stay of the proceedings, in title suit number 64/2003, which was pending before the Court of the Civil Judge Senior Division number 1, Silchar, the said stay order stands vacated, and the parties are directed to appear before the learned trial court, that is the Court of the Civil Judge Senior Division number 1, Silchar, on 10th of July 2024. It is, however, seen that the respondent in the instant proceedings is not represented today when the matter is being taken up. As such, before proceeding, the learned trial court shall issue due notice to the counsel, to the defendants in the said suit.
may pray both the parties. I have also no contact with my client. May both the parties. Notice may be issued. Dependent as well as
You are appearing, I can't say that. No? How can I say that? You can very well ask that court, whatever may be. But I can't say that. No? If you are appearing,
so and
the registry cell is directed to forthwith send the records back to the trial court. That is the Court of the Civil Judge number 1, Silchar.
my lord, civil judge may not have now jurisdiction.
Maybe, yeah.
Yes.
Civil Judge number 1. So that the suit can be taken up on the next date so fixed. In that regard, if necessary, the registry shall employ the services of a special messenger. Mr. S.K. Ghosh, the learned counsel appearing on behalf of the appellant, submits that taking into account
Pecuniary
the pecuniary jurisdiction which have already changed in view of the various amendments being made in the meantime to the Bengal Agra Assam Agra Civil Courts Act 1887. This court directs that in the circumstance the pecuniary jurisdiction have changed, the trial court, that is the Court of the Civil Judge number 1, Silchar, shall place the matter before the learned district judge for proper assignment to the appropriate court.
LCR may be LCR is
I've said special matter. That is why, Mr. Ghosh, I've asked the registry to get hold of all the SAOs, because these SAOs are like CRPIOs, which needs to be finished. Unnecessary. You see, this is your suit is of the year 2003. We are in the year 2024, 21 years have gone. In fact, the plaintiff must have thought that what has happened.
I have also no contact with the client.
Yes, what is this case?
But the
Is a remand?
The appellate says one issue, new issue was framed and remanded the suit. Remanded the appeal. And I being plaintiff, we being plaintiff, we lost the case in the trial court.
You are the plaintiff?
Yes.
You are the defendant?
Yes.
He has filed his appeal?
Yes.
None appears on behalf of the appellant on call. Mr. D. Chaudhary, the learned counsel appears on behalf of the respondents. This is an appeal under Order 43, Rule 1T of the Code of Civil Procedure 1908, challenging the order date. No. 1U. I got to 1U.
1 year.
1U. 1U. Challenging the order dated 28/2/2008, passed by the Court of the Civil Judge Lakhimpur, North Lakhimpur, entitled Appeal number 11/2007, whereby the learned First Appellate Court had remanded the suit back to the learned trial court, that is the court of the Munsif number 2, North Lakhimpur, for deciding the suit afresh, along with an additional issue which was framed by giving both the parties opportunity to adduce evidence. Taking into account that none has appeared on behalf of the appellant on call, this court therefore dismisses the instant appeal for default. The registry is directed to forthwith transfer the records, the LCR, to the court of the learned Munsif number 2, North Lakhimpur, and in that process, if necessary, employ the services of a special messenger. Forthwith. This court fixes the matter before the learned trial court, that is the court of the Munsif number 2, North Lakhimpur, on 17th of July 2024. Taking into account that the appellant herein, who is the defendant, is not represented, the learned trial court shall issue notice before further proceeding with the said suit. itu kini kaya ilarit. Wait, let me finish up first with this essay also. Then I'll take it.
Lord Chief, this is appeal under Order 43, Rule 1Q, Order of Remand, passed by the learned First Appellate Court, Civil Judge number 2, Kamrup, demanding a matter to the learned trial court, directing him to frame an issue and decide the matter. To frame an issue and decide the matter at first. At page 18. Appeal is preferred by defendant counterclaimant. Plaintiff suit was dismissed, and as against that, and a counterclaim was allowed by the learned trial court. As against that, only one appeal was preferred by the plaintiffs.
You were the,
I was the defendant counterclaimants.
your counterclaim was dismissed.
Decreed.
And who filed the appeal?
Appeal was filed by the plaintiffs for the special
Whose suit was dismissed?
dismissed.
And thereupon, against the counterclaim.
No, they have not said anything. Only one appeal was preferred.
Okay,
Either
anyway, so they have now challenged that judgment.
That's
It was a combined judgment of both the
Both,
suit and the counterclaim. Now, the trial court, the first appellate court remanded it by framing a fresh issue.
The issue was not framed, only direction was given to frame an issue at page 18.
No, it is given. After hearing the learned counsel for the, I have found that this appeal revolves around the question as to whether the appellants acquired any title over the suit land by virtue of the sale deed executed in favor by Pathik Chandra Loskar.
Look,
So this is an additional issue being framed.
see, that issue which suppose sale deed is a what kacha deed.
Huh?
Exhibit 1 and 2 is a kacha deed, only a possessory right. And there was no signature in the exhibit 2.
They were asking for what?
They are asking for possessory right, declaration of possessory right.
Okay. So then,
London trial court decided that their possessory right, it was 2005, they said they claim to have purchased the front of the protection notice.
from whom?
Law.
From Pathik Chandra
Law.
Loskar.
And said protection law, again, he claimed that he has purchased the land from the defendant number 1 and 2 by another kacha deed, wherein there was no signature of this defendant number 1 and 2.
So you mean to say that the evidence was already there.
Yes, sufficient.
So therefore the question could
Question of
not
man
have
does
been
not
raised.
arise.
Is a suit falling in the tribal belt?
No, Lordship.
Then why these kacha deeds and all?
Kacha deed.
What is your right?
My right, I have
What did you ask for?
I was annual patta holder. Thereafter, I applied for periodic patta. Accordingly, same was granted to me.
So you asked for declaration of your right title in.
Yes, Lordship.
So that was decreed
That was decreed
on the basis of documents.
on the basis of the exhibits or the by patta issued to me.
Who is Dijen Das and Koruna Das? The appellants.
Lordship, no. Appellants are Govinda Vishwa and Opal Vishwa. Digendas, actually, they have the other parts of the, there are four bighas of land. We are concerned about the 1 bigha 2 kotha something. These 2 persons had already purchased from us, Digendas and Kurunada, remaining land. So they are there.
And these Dijen Das and Koruna Das, what did they do?
They do not have anything to do with this suit land. Suit land is only 1 bigha, 1 bigha some kotha.
You are Govinda Vishwa and Gopal Vishwa.
Gopal Vishwa.
You got the periodic patta.
Yes, Lord.
And pursuant to the periodic patta, did you sell it to Dijen Das
This
and Koruna Das?
Digendas and Kurunada.
You sold it.
They sold.
Then What right do you have?
No, not entire. Not entire. Part of that. 3 bighas we have sold it to them. Another 1 bighas was left with us.
And what did these Dizendas and Coronadas do? They sold it to the
No,
plaintiff.
they did not. They claimed it that they have purchased it from with the 1 protection offer by a Kacha deed. Thereafter, they claimed it that it was purchased by protection offer from us, the Govinda Vaishya and Gopal Vaishya, by a Kacha deed, wherein there was no signature. Thereafter, said protection offer again subsequently sold it to the appellants by another Kacha deed. These 2 persons did not contest it.
This is an appeal under Order 43, Rule 1U of the Code of Civil Procedure 1908, challenging the order dated 11/6/2010, passed in title appeal number 6/2010 by the Court of the Civil Judge number 2, Kamrun Metro at Guwahati, whereby the suit was remanded back to the trial court and was decided to issue and was directed to decide the suit afresh by framing an additional issue as to whether the appellants in the said appeal acquired any title over the suit land by virtue of the sale deed executed in their favor by Pathik Chandra Law Court. For deciding as to whether the learned First Appellate Court had exercised the jurisdiction of remanding the suit in conformity with the provisions of Order 41, Rule 23A, or the learned trial court, First Appellate Court, or could have decided this, whether the order dated 11/6/2010 is contrary to the provisions of Order 41, Rule 24 of the Code. This court finds it relevant to take briefly the facts involved in the said suit. Facts involved which has led to the filing of the instant proceedings. The respondents herein, as plaintiffs, had filed a suit being title suit number 22/2007, seeking inter alia a declaration of their possessory right over the suit land, semicolon, for decree to pass a decree declaring the issuance of KP Patta number 58 of village Dokhin Sitara under Panduri Moja in the name of the defendant numbers 1 and 2 as unlawful, ineffective, and null and void, semicolon, to pass a decree confirming the possession of the plaintiffs over the suit land and for permanent injunction, etc. It is relevant to take note of that the scheduled land pertains to 1 bigha covered by dark number 70 of old yearly periodic patta number 8 oblique new KP patta number 58 of village Dokhin Sitara under Panduri Moja. The entire case of the plaintiff is that the plaintiffs have been residing in the suit land since 25/1/2005, which was purchased from one Phatik Chandra Lohkar through a Kacha sale deed dated 25/1/2005. And the registered deed could not be executed as the land of the yearly patta, as the land was a annual patta. It was stated that the annual patta, the land in annual patta number 8, containing dark number 70, originally belonged to the defendant number 1 and 2, who are the appellants herein. And subsequently, the defendant number 1 and 2 had transferred the suit land to one Patrick Chandra Lohkar. And thereupon, the said Patrick Chandra Lohkar transferred the suit land to the plaintiff number 6, as well as the predecessor in interest of the plaintiff number 1 to 5 on 25/1/2005 by the unregistered deed of sale dated 25/1/2005. It was also stated that the defendant number 1 and 2 transferred 2 bighas of land of the periodic patta number 8 of dark number 70 to the defendant number 3 and 4. The entire cause of action for the suit was on 20/4/2007, the defendant number 3 and 4, accompanied with their father, forcefully entered into the suit land, broke the entrance part of the plaintiffs, standing over the suit land. It was stated that the defendant number 3 and 4 and their father claimed that they had purchased the whole dark number 70 from the defendant number 1 and 2 through the registered sale deed. And so the plaintiff was compelled to file the suit. It is the further case of the plaintiff that the conversion of the annual patta in favor of the defendant number 1 and 2 and the sale made by the defendant number 1 and 2 to the defendant number 3 and 4 was absolutely illegal. And as such, the said suit was filed seeking the reliefs as aforementioned. The defendant numbers 1 to 4 filed a written statement, and the defendant number and a counterclaim was also filed by the defendant numbers 1 and 2, claiming inter alia, denying the entire case of the plaintiffs, and claiming inter alia that Patik Chandra Loskar had no right, title, or interest to transfer the scheduled land in favor of the plaintiffs. It was mentioned that the defendant number 1 and 2 was issued the periodic patta, and some area of the land after the issuance of the periodic patta was transferred to the defendant number 3 and 4. However, the land which was situated, however, the suit land was not transferred to the plaintiffs, to the defendant number 3 and 4. On the basis of the counterclaim, the plaintiff, the defendant number 1 and 2, sought for declaration of their right, title, and interest over the suit land, semicolon, seeking eviction of the recovery of khas possession of the suit land from the plaintiffs, as well as for permanent injunction. The plaintiffs filed their written statement to the said counterclaim. On the basis of the above, the learned trial court framed as many as 7 issues, of which issue numbers 1 to 4 related to the suit, and issue number 5 to 7 related to the counterclaim. On behalf of the plaintiff, as many as 6 persons have adduced oral evidence, and on behalf of the defendants, 3 persons have adduced oral evidence. On behalf of the plaintiffs, various documentary evidence were placed, which were marked as Exhibit 1 to Exhibit 8. On behalf of the defendants, the defendants exhibited various documents marked as Exhibit A to Exhibit C. The learned trial court, on the basis of the evidence on record, dismissed the suit by the judgment and decree dated 23/11/2009, dismissed the suit and decreed the counterclaim. Being agreed, an appeal was prepared, which was registered and numbered as title appeal number 22/2007. An appeal was prepared by the plaintiffs, which was registered and numbered as title appeal number 22/2007.
Lordship, that is TS 6/2010, title appeal.
TS
TS 6, TS is 22/2007.
had being titled, an appeal was filed by the appellant, by the plaintiffs. One of the plaintiffs,
Lordship,
which was registered and numbered as title appeal number 6/2010.
Lordship.
The learned first appellate court, by the impugned order dated 11/6/2010, had remanded the suit by setting aside the judgment and decree dated 23/11/2009, thereby giving due opportunity to both the parties to adduce evidence. It is under such circumstances the instant appeal has been filed. Mr. B.K. Bhagavati, the learned counsel appearing on behalf of the appellant, submits that a perusal of the impugned order dated 11/6/2010 would clearly show the total non-application of mind, inasmuch as the learned first appellate court did not consider that the evidence was already there on record, on the basis of which the appeal could have been disposed of. Referring to paragraph number 14 and 15 of the impugned order, he submitted that there is no reasons also assigned by the learned first appellate court as to why the case is required to be remanded. More so, the framing of the additional issue was not at all necessary, taking into account that the issue number 3, so framed in the suit, would have very well decided, issue number 3 have already is inclusive of the said issue. He therefore submits that this is a fit case where the impugned order requires to be interfered with. I've heard none has appeared on behalf of the respondent on call. This court have duly perused the materials on record, as well as the exhibits, as well as the evidence, as well as the evidence. And this court have duly perused both the oral as well as the documentary evidence on record. In addition to that, if this court takes note of the judgment of the learned first appellate, the order passed by the learned first appellate court, there is no reason as to why the case was required to be remanded back to the trial court. Or for a purpose, or the requirement for framing an additional issue. More so when the issue number 3 categorically mentions, relates to, as to whether the plaintiffs are entitled to declaration of the possessory right on the basis of the unregistered deed of sale executed by, allegedly, purportedly executed by late Pratik Chandra Lokar. Under such circumstances, now, in addition to that, this court also finds the impugned order to be contrary to the to the provisions of Order 41, Rule 24 of the Code. Consequently, this court therefore sets aside the impugned order dated 11/6/2010, passed by the learned First Appellate Court, entitled Appeal number 6/2010, and further directs the learned First Appellate Court, that is the Court of the Civil Judge number 2, Kamrup Metro
No,
at
no,
Guwahati.
Now it will go to the Samingaon now because Kamrup has become the rural Kamrup.
I can't send it there. Nah. How can I send it there?
Oh Lordship, in that case, let it go here only. Here only. I have problem.
Direct. Ki likh liye tu? First Appellate Court, that is the Court of the learned Civil Judge number 2, Kamrup Metro at Guwahati, for deciding the said appeal within a time frame, taking into account that the suit, taking into account that the appeal is of the year 2010. Mr. B.K. Bhagwati, the learned counsel here, on behalf of the appellant, submits that the land in question,
In India.
the suit land in question, is a land now falling within the jurisdiction of
Kamrup rural.
the learned district judge Kamrup,
Rural.
Aminga.
Amin.
Taking into account it would not be proper. This court is of the opinion that it would not be proper on the part of this court to remand the suit, to transfer the suit in exercise of the powers presently done, in exercise of the powers under Order 43, Rule 1U of the Code. However, observes and directs the Court of the Civil Judge number 2, Kamrup Metro at Guwahati, as well as the learned district judge, Kamrup Metro at Guwahati, that in the circumstance the dispute does not fall within their jurisdiction, the suit, the appeal be transferred to the appeal, as well as all records connected therewith be transferred to the Court of the District Judge, Kamrup Metro,
Kamrup rural.
Kamrup Rural, so that the suit, the appeal can be assigned by the by the court of the learned court, by the learned district judge, Kamrup Rural, to the appropriate court. This court directs the petitioner, the appellant herein, to appear before the learned first appellate court, that is the court of the civil judge number 2, Kamrup Metro at Guwahati, on 15th of on 8th of July 2024. The registry is directed to forthwith transmit the records and, if necessary, employ the services of a special messenger so that the records, the trial court records, along with a copy of the instant order, be transmitted to the LCR, be transmitted to the learned court of the civil judge number 2, Kamrup Metro at Guwahati, so that the said court is in a position to take up the matter on the date so fixed. Right. Yes, what is this?
May with the lordship. The instant appeal before the defendants, my lord, and the learned for the appellate court, my lord, demanded setting aside the findings of the learned municipal, my lord. Here in this question involved in the plaintiff, the pilot attitude for specific performance of a contract relying on one Payanama, my lord, 2003, my lord, and then, my lord, in the trial court, my lord, despite giving sufficient opportunity to the plaintiff, he failed to adduce any evidence. According to 26, 2008, evidence of the plaintiff is expunged, my lord. Same has not been challenged by the plaintiff. Sorry.
Where is the first appellate court's
I'm
order?
sorry. Page 6.
Page
Page 6.
3.
Page 6.
6. Elegant.
Elegant.
Why it has been sent?
For again, allowing the plaintiff to give a fresh evidence.
Why? This court has heard the learned counsel appearing on the plaintiff. You are the defendant.
I'm defendant.
The suit was decided in the inter party.
Against the plaintiff. Then he preferred appeal.
Inter party.
Yes.
Both parties were
Yes,
there,
Lord.
not
Yes.
ex parte.
Not expert.
The plaintiff suit was dismissed.
Missed.
So the court was more of a sympathetic view, isn't it? So your case is when the appellate court has all along held that the trial court was justified in doing all this thing. The appellate court should not have transferred, should have decided that
Only mind plaintiff has been given a chance, my lord,
transfer was.
to adduce evidence. That is the findings, my lord.
So why didn't you file an order 41
That is that
27?
they failed to file that applications.
Then
And
you file it there. I'm remanding it. File a suit. Then you may get a similar order. That this evidence was struck off, whatever may be. That can be done. But the line of trial court should have given that. The first appellate court should have done it. But not this.
only saying the interest of the state. That is
Sympathy doesn't.
that is.
Yes, what is your name?
PK Decker.
PK Decker. PK Decker. The learned heard Mr. PK Decker, the learned counsel appearing on behalf of the appellant, and Mr. N. Hawk appearing on behalf of the respondent. This is an appeal under Order 43, Rule 1U of the Code of Civil Procedure against the order dated 31/3/2010, passed in title appeal number 2/2009 by the Court of the Civil Judge Hailakandi, whereby the learned First Appellate Court remanded the suit back to the learned trial court for deciding the suit afresh. From a perusal of the impugned order, it reveals that the learned trial court, the first appellate court, had duly supported the view of the learned trial court in deciding the said appeal, the suit against the plaintiff on the ground, in dismissing the suit of the plaintiff on the ground that the plaintiff failed to adduce evidence. However, most strangely, and in complete violation to the provisions of Order 41, Rule 24 of the Code, the learned First Appellate Court had taken a sympathetic view of the matter, which is never not conceived of in law, and thereby remanded the suit to the learned trial court for deciding afresh by permitting the parties to again adduce evidence, permitting the plaintiff to cross-examine the defendants.
Plaintiffs.
Huh?
Cross-examine the plaintiffs.
Permitting the defendants to cross-examine the plaintiff witnesses. That is what. With the direction that the plaintiff witnesses shall be allowed to be cross. In the opinion of this court, the said order being completely contrary to the provisions of law, the said requires to be interfered with, and accordingly this court hereby does so by setting aside the impugned order dated 31/3/2010. This court further directs, taking into account both the parties are duly represented, they are directed to appear before the learned court of the Civil Judge Hailakandi on 17th of July 2024. The registry is directed to forthwith transfer the records of the instant appeal, transfer the LCR to the courts, to the court of the learned Civil Judge Hailakandi, so that the said appellate court, the first appellate court, is in a position to decide the said appeal in accordance with law.
Yeah, statement.
What?
There is this stay, trial court finding,
Huh?
there is stay order passed by this court,
What state? Say nothing.
Plus, take the
I've directed this, huh?
Yes,
In
if
view
the-
of the other, in view of the above observations, any interim orders, if any, stands vacated.
take the
Pratik,
Here, my name is appeared, but surprisingly, I am not engaged in this case. I examined the Okolotnama, my signature is not there. But after looked at his file, his name is there, madam. So this why I want. I clarify. My name should not be reflected.
Yes, yes. We may allow the appeal. You stand up. Okay. Take a seat now. Okay, Mr. Bulwa, your presence is dispensed. Dismissed. This is an appeal under Order 43, Rule 1U of the Code of Civil Procedure, challenging the order dated 21/12/2011, passed by the Court of the Civil Judge number 3, Kamrup, Metro at Guwahati, whereby the learned First Appellate Court had remanded the suit back to the learned trial court, thereby for deciding the suit afresh by giving an opportunity to the appellant defendant to cross-examine the plaintiff witnesses and to adduce evidence, if any. None has appeared on behalf of the appellant on call. The above, in view of the above, this court, it is the opinion of in view of the above, the instant appeal stands dismissed. Interim orders, if any, stands vacated. The records of the pustak. Taking into account that none of the parties are appearing. This court fixes the matter before the learned trial court. Before the learned trial court, that is the court of the Munsif number 1, Kamrup Metro at Guwahati, on 15th of July 2024. The registry is directed to forthwith transmit the records to the said court so that, and if necessary by employing a special messenger, so that the said records are available before the court of the Munsif number 1, Kamrup Metro at Guwahati on the dates so fixed herein above by this court. Taking into account that none of the appellant as well as the respondents are present before this court, the learned trial court shall proceed for disposal of the suit by issuing due notice to both the parties.
Shah Lordship, the respondent filed a suit lordship for a specific performance of contract. Appellant is a builder and the respondent has booked a flat. The respondent as a plaintiff has filed a suit for a specific performance of the contractor. And the present appellant is the builder. So the respondent has booked a flat lot. He pays some advance amount. Thereafter, he never paid the balance amount lordship, but he had taken the possession of the flat.
Who the
Respondent flat.
the purchaser?
He had taken the possession of the flat lordship, and but he never paid the balance amount. So ultimately, by a letter issued by the builder lordship, that is the appellant, the agreement was cancelled, which was lordship challenged by filing the suit for a specific performance of contract. But interesting in the prayer portion, lordship, there is no prayer for the specific performance of contract, that is for registering of the sale deed, that your lordship will find as page 10 is the plaint lordship, amended plaint, and prayer portion is lordship at page 20. Prayer number declaration that the letter dated 28/6/4 of the defendant number 1 is illegal, unauthorized, inoperative, and not binding on the plaintiff. Directing the defendant number 1 to determine the cost of the common area on the basis of 20 square feet only, extent of instead of 83 square. Directing the defendant number 1 to repair the damaged walls and provide the flooring of the flat as available garbage causes as per the brothel. Directing the defendant number 1 to pay a compensation of this month. So these and issue mandatory. These are the things. There is no prayer for declaring of the suit for a specific performance of the contract in question law. Then ultimately the suit was dismissed by the learned trial court, holding that as the plaintiff respondent has failed to pay the balance consideration amount as per the time limit schedule fixed in the agreement lordship, and amongst other grounds, the suit was dismissed. Against which lordship title appeal was preferred by the purchase. The learned trial court in the impugning judgment has remanded the matter lordship, directing by framing an additional issue lordship, which was not required at all. All the evidences are sufficient lordship to decide the appeal. That additional affidavit, the impugned judgment your lordship will find at page annexure 10, page 115. And remanding order, your lordship will find. Additional issue was framed, lordship, page 120, para 2.
Where is the decision by the trial court as regards the letter which was sought to be, wherein the declaration was sought for cancellation?
Yes, Lord. Page 80.
Where?
That the plaintiff aware that by the notice
Paragraph?
paragraph number, lordship,
Which issue?
80.
Hmm?
Paragraph 80. Page 85. Start from page. Issue number 1. The next para finding is there.
That is a question of limitation.
Question of limitation, lordship, the learned trial court consider the article 54 of the Limitation Act. And
When he is not asking for specific performance of that agreement, where is the question of limitation being going into by the trial court?
Correct, Lord.
But where is the decision as regards the letter?
Yes.
Because
Lord,
by that letter you cancel the agreement.
I can.
Where is the finding out here that the cancellation was proper?
Page 86, lordship.
Page?
Page 86. That the plaintiff averred by the notice dated 28/6/04, the defendant number 1 refused to perform its part of the contract. There is no averment in the plain as to when the plaintiff received.
No. That is not the. When is the letter for how did you cancel the agreement? Because the cancellation of an agreement has far-reaching consequences. Where is the decision by the trial court? When he is not asking for specific performance, the court has gone into a question of specific performance. He is asking that the agreement should not have been cancelled. Where is the decision? There is no decision.
Plain discloses that the suit he has filed for a specific performance of contract. But in the prayer portion, there is no prayer for the specific for passing it.
He may not ask. He may not ask for specific performance, whatever may be. I am happy. I am in possession of this property out there. But the moment you cancel it, the agreement on the basis of which he is staying out there, it has the far-reaching consequences. He becomes an illegal possessor. Where is the decision?
Can the trial court find that there is no evidence from the side of the plaintiff regarding the notice dated 28?
No, whether the trial first, whether the defendant could have cancelled the agreement is the prime issue which the trial court ought to have decided or even framed that. It have not been done. This is an order. This is an appeal filed under Order 43, Rule 1U of the Code of Civil Procedure 1908, challenging the order dated 27/9/2011, passed in title appeal number. What is the appeal number? 14/2010, whereby the learned trial court, first appellate court, that is the court of the additional district judge Kamrup, Guwahati, had remanded the suit back to the court of the learned civil judge number 2 Kamrup Metro at Guwahati, in title suit number 292/2004, to decide the said suit afresh, along with the additional issue which was framed. I've heard Mr. S.P. Roy, the learned counsel, appearing on behalf of the appellant, and Mr. S. Saikia appearing on behalf of the respondent. This court have duly perused the copy of the plaint, wherein, amongst various reliefs which have been sought for, one of such relief is the declaration that a letter dated 28/6/2004, issued by the defendant number 1 as illegal, unauthorized, inoperative, and not binding on the plaintiff. It is relevant to take note of that by that letter dated 28/6/2004, the agreement entered into by and between the plaintiff and the defendant number 1 on 31/3/2001 was cancelled. This court, however, have also perused the written statement which has been filed by the defendant number 1, 2, and 3. Surprisingly, the said was a very vital issue as to whether the defendant number 1 could have cancelled the agreement entered into between the plaintiff and the defendant number 1 by the letter dated 26/4/2004. This court have perused the judgment and decree passed by the learned first trial court. And from the said judgment and decree, there is nothing apparent to show that any issue was framed as regards the legality and validity of the letter dated 28/6/2004, or for that matter, as to whether the defendant number 1 could have at all cancelled the agreement, registered agreement dated 31/3/2001. The learned trial court thereupon dismissed the said suit by the judgment and decree dated 10/6/2010. Being agreed, an appeal was prepared, which was registered and numbered as title appeal number 14/2010 before the additional district judge Kamrup Metro, Kamrup, Guwahati, which was endorsed for disposal to the court of the additional district judge Kamrup, Guwahati. The learned First Appellate Court, in the opinion of this court, have rightly framed the additional issue and remanded the suit back to the trial court, taking into account that a decision on the said issue as to whether the letter dated 28/6/2004 issued by the defendant number one is issued by the MSRB Engineering and Company India to the defendant number one was illegal and not binding upon the plaintiffs. Inasmuch as the said issue would have far-reaching consequences on the rights of the plaintiff and the suit to be decided. Accordingly, this court is of the opinion that the judgment and order passed on 27/9/2011 does not require any interference. Ordered it from this court. Taking into account that both the parties are duly represented, the parties are directed to appear before the learned court of the civil judge number 2, Kamrup Metro at Guwahati on 12th of July 2024. The registry is directed to forthwith transfer the records to the court of the learned civil judge junior division, civil judge senior division number 2, Kamrup Metro at Guwahati. So that on the next date, so fixed herein above, the said court is in a position to proceed with the trial in accordance with law. Interim orders passed, if any, stands vacated.
Item 8.
Yes, what is this?
Finally, pass over for the timing your lordship.
Why?
Senior is on legs, your lordship.
Huh?
My senior is on legs, your lordship.
Where is the impugn order?
My lord, the brief case is that the plaintiff, my lord, the,
You are the defendant?
yes, my lord, I'm defending 1, 2, and 3. That the ancestral property was mutated in the name of plaintiff, my lord, and he,
Did you ask for partition? Did you ask for partition? You have a right.
yes, my lord,
If you claim any right out there, you have a right to
yes,
partition.
no particular
Whether you
partition.
have filed a ask for partition, the plaintiff says that there is nothing. The entire schedule A land is mine. So you have not asked for partition. You didn't file a counterclaim.
No, counterclaim, but there is no partition that in WS it is stated that there is no partition, and
So
except
therefore,
the
whether there was
defendant,
a no,
other 6 daughters also there, my lord, that the co-sharer, that is, my lord, stated in the WS.
maybe, but whatever may be, you didn't have a case of partition. Why was that issue at all being required to be framed?
Because my lord, para 3 of the WS, my lord, para 3 of the plaintiff, my lord, that is stated in the, my lord, appellate judgment, my lord.
Hmm.
In page 12, my lord,
Hmm.
para 13,
Hmm.
page 13, para 13. After hearing the submission of both parties, perusing the case record, the trial court, and evidence adduced both the parties, I have found that learned trial court failed to interpret the law of inheritance. The senior counsel,
So without a partition,
my lord, without partition.
why is it required that the question of partition required possession of the co-owner upon the partition less is meaningless in declaring the right title interest in view of the amount of considered demand as the result is decided afresh. What is the issue frame? Whether estate has left whether the estate has left surviving him as a child or children, but no more remote lineal descendant to deceased man, the property shall belong to the surviving child if there is only one, or shall equally be divided amongst the surviving children. Now, if it is your case that it's a case of partition, then whether the plaintiff has right title and interest over the suit land,
Only on the basis of
that issue could have
that, my lord,
that there was no
only
partition.
on the basis of, my lord,
So
that
the evidence was
Jamapati,
very much there.
my lord. But the co-sharer, even if his name is mutated, my lord,
So isn't that the case the first appellate court should have considered? Your appeal was what?
so that's
Your
considered.
appeal was, look here, the land was partitioned. I have a share of the over land, and as such he could not. And mere entries made into a record of rights would not confer him any title. That's all.
That's what that could have done by the trial
First
court
appellate
itself.
court. The first appellate court could have looked into it
Yes, my lord.
on the basis of issue number 4. Why is the requirement of a very complicated issue for that? As the simple issue is, it's a simple suit, wherein the plaintiff says that, look here, the entire property belonged to so-and-so. After that, I got the mutation in respect to this Schedule A land, of which Schedule B land was a 4-bigger plot of land, which was taken over by, I was dispossessed, so I want the declaration of Schedule A land and also for recovery of possession of Schedule B land.
That's
It's a
fine.
very simple case. The other side says that, look here, I have been allowed to stay out there in these particular 20 bighas of land or whatever amount of land I was there.
Mm.
And I have all along, I have cultivated.
Yeah.
And as such, I have a right out there because I am the father's son.
Yes,
And as such, he doesn't have an absolute right
Absolute
to
right.
that fact. So under such circumstances, where is the question of anything else is required to be done? This could have been very well decided while deciding the issue number 4 by the first appellate court as to whether he had the right on the basis of the evidence.
would have, but without
The problem
doing
arises
so,
is
my
that
lord, that
you,
they may remanded, that
Huh?
remanded by framing additional issue.
why is it required? The issue is very much
have.
in depth in issue number 4.
Lordship may remand this matter to the appellate court, or then
Yeah, no, I would interfere with this order and
Yes,
direct
sir.
the appellate court to decide on the basis of the materials.
Yes.
Now you want the senior?
No, your lord.
Let me put your name. Heard?
H. Darangti, your lordship.
Sorry. appearing on behalf of the appellant.
For respondent 1, 2, 3. Speak with sir.
Appearing on behalf of respondent. This is an appeal under Order 43, Rule 1U of the Code of Civil Procedure 1908, challenging the order dated 28/6/2012, passed in title appeal number 5/2012 by the Court of the Learned Civil Judge Udalguri, whereby the Learned First Appellate Court, by framing an additional issue, had remanded the suit back to the Learned Trial Court for decision afresh. By permitting the parties to adduce fresh evidence for deciding as to whether the Learned First Appellate Court was justified in remanding the suit or not. This court finds it relevant to take note of the brief facts leading to the filing of the instant proceedings. The respondent herein, as plaintiff, had instituted a suit before the court of the Munsif at Udalguri against the appellants herein. How many appellants? 3. How many appellants?
Plaintiff, plaintiff file a suit. Plaintiff is the appellant here.
Huh?
And plaintiff suit was my lord.
Against the respondents.
Plaintiff suit was
Against the
decreed.
respondents herein, who were the defendants. A perusal of the plaint of the said suit reveals that the original pattada, owner of the Schedule A land was one Lolit Doimari, since deceased. The plaintiff and the defendant number 1 are the sons of late Dolit Doimari. It was alleged that after the death of late Lolit Doimari, the defendant number 1 separated and was living separately and was separated and used to live separately along with their respective families. It was the specific case of the plaintiff that after the death of late Lolit Doimari, the his movable and immovable properties were duly separated. And the land in Schedule A fell into the share of the plaintiff. This Schedule A land, which is contained in the periodic patta, was mutated in the name of the plaintiff in place of his father, late Lolit Doimari. The defendant number 1, along with the defendant number 2 and 3, who are the sons of the defendant number 1, disposes the plaintiff from a part of the Schedule A land, which have been more specifically described in Schedule B. It is under such circumstances the suit was filed seeking declaration of right title and interest in respect to Schedule A land in favor of the plaintiff, as well as for recovery of the possession of the Schedule B land and confirmation of possession in respect to the remaining portion of the Schedule A land. The said suit was registered and numbered as title suit number 2/2010. Huh? 2 or 2? Title suit number 2/2010. 2/2010. The defendants jointly filed a written statement stating that the land originally belonged to late Lolit Doimari, their father, and the properties of the father have not yet been partitioned. And as such, the question did not arise of sharing of the properties equally by the plaintiff as well as the defendant number one. It was stated that the defendant was in possession of the Schedule A land. He has been in possession of the Schedule B land. Since the last 26 years. And as such, the question of dispossession of the plaintiff did not arise. In addition to that, it was stated that the schedule in addition to that, it has mentioned that amongst the plaintiff and the defendant number one, the plaintiff was literate, whereas the defendant number one was not. And as such, he had illegally inserted his name in respect to the entire Schedule A land. It is, however, interesting to take relevant to take note of that the defendant did not seek for partition. On the basis of the said suit, the pleadings being filed, the learned trial court claimed as many as 6 issues, claimed as many as 7 issues. Amongst the 7 issues, issue number 4 and issue number 6 are relevant. Inasmuch as issue number 4 pertains to as to whether the plaintiff had right title and interest over the suit land, and issue number 6 is as to whether the defendants have right title and interest over the suit land to possess the same. The learned trial court, by judgment and decree dated 29/1/2011, decreed the suit in favor of the plaintiff being aggrieved. The appeal was preferred, which was initially numbered as title appeal number 2/2011, subsequently renumbered as title appeal number 5/2012. The learned first appellate court, by the impugn order, remanded the suit on the ground that the question of partition should have been a separate issue which ought to have been framed. And the declaration could not have been granted. Declaration as well as for recovery of possession could not have been granted since the question of partition not being decided. It is under such circumstances an additional issue was framed and thereby remanding the matter back to the learned trial court for deciding the entire suit afresh along with the additional issues so framed. It is under such circumstances the present appeal has been filed before this court challenging the order dated 28/6/2012, passed in title appeal number 5/2012. I've heard, good edition. The submissions of the learned counsels appearing on behalf of both the parties have been duly considered. This court had put a specific query upon the learned counsel, Mr. So-and-so, appearing on behalf of the respondent, as to whether the issue number 4 and issue number 6 could have very well, could not have decided the issue of partition, or as to whether there was at all any partition amongst the parties. More so, taking into account that the parties did not seek a partition. The learned counsel appearing on behalf of the respondent duly submitted that taking into account that the parties did not seek for specifically for the relief for partition, the fact as to whether there was a partition amongst the plaintiff as well as the defendant number 1 after the death of the father could very well be decided in terms with issue number 4 and issue number 6. This court is also of the opinion that taking into account the issue number 4 and issue number 6, and there being no prayer for relief sought for partition by either of the parties, the learned first appellate court ought not to have framed the additional issues and remanded the suit back to the trial court for a decision afresh. It is very pertinent to take note of a well-settled principle of law that a co-sharer has a right to seek, co-owner has a right to seek partition. But the question as to when a co-owner seeks a partition is absolutely within his or her volition. Therefore, there is no limitation also prescribed in law as to when a partition is required to be sought. Inasmuch as the right to separate from the other co-owner is a continuing right. Taking into account the above, this court is of the opinion that the learned first appellate court erred in law in remanding the suit back to the learned trial court by framing an additional issue, more so when there was no partition sought for by either of the parties. This court also have taken note of that the evidence on record, which also shows that the evidence were already there. On the basis of which the learned first appellate court could have decided the suit appeal And as such, it is the opinion of this court that remanding the suit is also in violation to the provisions of Order 41, Rule 24 of the court. Considering the above, this court therefore sets aside the order dated 28/6/2012, passed in title appeal number 5/2012, and directs the learned First Appellate Court, that is the court of the civil judge Udalguri, to decide the title appeal number 5/2012 on the basis of the materials available on record. This court further directs both the parties to appear before the learned trial court, First Appellate Court, on 17th of July 2024, on which date the First Appellate Court, upon appearance of the parties, shall take appropriate steps for disposal of the said appeal in accordance with law. The registry is directed forthwith to transmit the records back to the learned First Appellate Court, that is the court of so and so, and also to take note of that this court had duly fixed the date before the learned First Appellate Court, and take appropriate steps so that the records are available on the next date before the learned First Appellate Court, if need be, employ the services of a special measure. You can give additional evidence under Order 41 Rule.
Yes.
See, there is a judgment of, I think, 1952 Assam. A very beautiful judgment as to why there is no requirement for, there is no limitation for partition.
Yes, madam. Continue.
It's always a continuing offense because it depends on the volition of the party as to when I want to separate.
Yes, madam. If any legally are also, my lord.
He may not like, but that is why it is held. Yes.
Make with the lordship. Lordship, in this case, your lordship, I am partially handicapped because the brief has not been traced, your lordship.
What?
The brief of the case, your lordship, could not be traced. And also, as per my instruction, your lordship, the appellant and the respondent have also in the meantime expired.
Both have expired.
Yes, in the day, way back 2015, your lordship. The appeal is filed challenging the order of remand.
We do one thing. We dismiss for default. If the appellant has expired, it will abate. If I dismiss for default, the order remains. Order remains, you had to go, because what has happened, the problem which has happened out here is this. The learned trial court, without identifying the suit, the decretal property have issued, which was the requirement. The requirement under Order 7 Rule 3 as well as Order 20 Rule 6. Because later on it becomes a difficulty. And it is the duty enjoined in view of Pratibha Singh's judgment. That is why it has now been referred back. But if I say it to be abated out here, it would have it will again be unnecessarily delayed. I can abate it, but you don't have the details. Do you have any connection with this client?
No, no. Even in the suit, your lordship, the decree which was passed, your lordship, it is as such that the authority will do the demarcation, your lordship. Thereafter, the The respective parties will be vacated from their plot of land, Your Lordship. It is not a complete degree, Your Lordship. A preliminary degree was partly by the trial,
It's a suit for partition.
Lordship.
It's against the preliminary decree.
Preliminary degree.
So the suit is pending.
That was disposed of.
The suit will be pending because when you go for a preliminary decree, the suit is pending.
There was
The
a
suit
direct,
for what?
there was a direction, Your Lordship, that the parties, Your Lordship, they will approach the authority. Authority will properly demarcate the plot of the land, and accordingly the parties have to abide by their whatever findings of the authority.
And the suit was disposed.
Yes, yes.
What was the properties? Both have died. Your
Yes,
person died.
Yeah,
Your person died. It has been informed to this court by Mr. H. Buragoy, the learned counsel. Borgoy or Buragoy? Buragoy, the learned counsel appearing on behalf of. That day in that matter, I put your name. Huh? They have not put it, although you say that you are no longer there, but I put it your name. That Mr. P.S. Deka was there. Na? It has been submitted by Mr. H. Buragoy, the learned counsel appearing on behalf of the learned counsel who appeared on behalf of the appellant, who appears on behalf of the appellant, and Mr.
S.K. Sohoria.
S.K. Sohoria, the learned counsel who appears on behalf of the respondent.
Yeah.
Told.
Two.
Respond number
Both Tilottama, both the response.
for the respondent.
Niruvama,
That who had died?
Tilottama.
That the appellant as well as the respondent number one had expired sometime in the year 2015.
Appellant died in the year 2015.
Appellant died in the year 2015 and the respondent number one died in
23.
the year 2023. So taking into account, no steps have been taken. The appeal abates, for which an appeal abates and accordingly closed. The registry is directed to return the LCR to the court of
Civil judge, junior division, not Salmara.
civil judge.
Junior division.
No, senior division.
Not Salmara.
Senior division Bongaigaon. Senior division Bongaigaon. For due compliance to the judgment and order dated, the order dated 13/5/2013 passed in title appeal number 14/2006, whereby the suit being title suit number 18/2007 was remanded back to the trial court to dispose of the suit afresh in terms with the observations made therein. I can't pick the date. Interim orders, if any, can pick it.
Published.
You are appearing?
And protest.
Yes.
My lord, it was remanded back for de novo trial. My lord. The finding of the appellate court is that my lord, the amendment was just fought. My lord. It was rejected. Suit has been dismissed on appeal. My lord, the first appellate court held they actually fought for amendment at the later stage, which was rejected by the trial court and dismissed the suit. My lord. And on this ground, my lord, the appeal has been remanded back for de novo trial.
Why was the amendment rejected?
Because it was filed in later stage, my lord. That is cross examination of the plaintiff.
Suit for what?
Suit for my lord
Declaration.
declared.
Did you point it out in your proceeding? Did you point it out in your written statement? Declaration of what? Right title interest.
Right title interest, right title interest.
And they filed an application for amendment of the claim to include the recovery of
Recovery of funds in the later stage.
that was rejected.
That was rejected. And suit has been dismissed. Because my lord, as per the section 34, my lord, whole there has to make my lord. And as such, my lord, the recovery part, my lord, they did not mention the recovery part. Therefore, this suit has been dismissed. And appeal it was reversed again, saying that no, as the amendment petition was rejected for recovery of position. My lord, therefore, the trial judge has to first given a chance to amend the claim. And therefore, it was sent back to the number of
So what is wrong?
My lord, as the trial judge has, my lord, rejected the amended claim, application, there was no revision or no appeal has been filed, my lord. And I didn't find anything.
Is a revision conceived? Is a revision conceived against an order and the order 6%?
No appeal or my lord, nothing has
Is an
been filed.
appeal prepared? Is an appeal conceived of against an order of rejection of order?
After 227, my lord, they taken preference.
227 is an extraordinary remedy.
Under one,
What do you say about section 105 of the city? Where any order passed by the court in the trial cannot be challenged in view under the code, you can raise that as a ground of objection in your memo of appeal.
but here, my lord, the petitioner
The different thing, 227 is there.
Yeah.
227 is an extraordinary remedy which the court may like, may not like, or whatever may. The different thing that we have been more lenient on that. But strictly speaking, 227 is not a remedy. 115 is a remedy, but 115 is not permitted. So then, what is wrong with the order?
So de novo proceeding, my lord, de novo trial means, my lord, the correction of the lacuna, which was, my lord, taken by the plaintiff, my lord. Otherwise, my lord, they knew that they had been dispossessed before the filing of the suit, my lord.
So therefore they file an amendment. When they
Amendment,
file it,
yes.
tell me, they filed an amendment. The amendment was rejected, rightly or wrongly. The trial first appellate court holds it, yes, it has been wrongly.
It's only for the correction of the lacuna, my lord. That's not,
Is it a suit for specific performance?
no.
For what?
So declaration, my lord. right title interest. Declaration of right title. And confirmation of possession. Confirmation of possession.
Show me your written statement.
Yes. 13%. Yes, 13.
Yes.
Yes, 13.
You have not raised that point in your written statement. That a suit is barred in view of the provisions to section 34. There's a Supreme Court judgment in 1961, it categorically says that you have to take. Apart from that, the suit was also a suit for based on declaration and permanent injunction. Within the permanent injunction, further relief. This was, I think, dismissed on the basis of that Ganga Devi judgment, Ganga Saran, 1973. Nothing is wrong with the order.
My lord, because they have said that during the pendency of the suit, they have been disputed. They are claiming that no, by not because starting of the suit were possession.
Did the court come to a finding that you have been possessing earlier?
So trial court, yes, my lord, trial
Did
court.
issue was framed? Because that is the question as to whether you were possession or not. That could have been only decided after full length trial.
And now, my lord, after it's allowed, my lord, then from very beginning it has to be because they are
You are claiming benefit under 53A. That's your case. That Subharam Busha, whoever it is, he entered into an agreement and put you into the possession, but did not execute, but sold the land to the plaintiff. That's your simple case. You are claiming under 53A.
yes. The problem is that, my lord, starting the de novo proceeding, my lord, they are going to amend the entire plan because the suit has been started.
Whether it is amended or not, that is, the court can very well decide that. But the first appellate court had looked into it and said that the order is wrong. Of rejection was wrong.
Suit was dismissed on the ground of that's not establish their title, my lord.
Hmm?
Trial court, my lord, they could not establish their title. But
We will remand it again remanded back, but however, the trial court shall decide the suit without being influenced by the observations made by the first appellate court in paragraph number 10, 15, 15, 17. Without being influenced by the observations made in paragraph number 1 to 7, 10 to 7. Because this will affect your entire thing.
Yes.
This is an appeal under section and order 43 rule 1U of the Code of Civil Procedure challenging the order dated 16/10/2015 passed by the learned trial court, passed by the learned first appellate court, that is the court of the additional district judge number 1, Kamrup Metro at Guwahati, whereby the title appeal number 5/2011 was disposed of by setting aside the judgment and decree passed by the learned trial court and directing the trial court to decide afresh the suit by allowing the plaintiff to file his prayer for recovery of khas possession of the suit land. Full stop. From the materials on record, it reveals that it is the case of the plaintiff that by the deed of sale, the plaintiff had purchased the suit land and was put into possession. The plaintiff remained in possession. However, on 11/4/1993, the defendant attempted to trespass into the suit land and start construction of the house. However, the said attempt was registered by the father of the plaintiff. Be that as it may, the defendant continued to disturb the possessions for which the plaintiff initiated the proceedings under section 145 of the Code of Criminal Procedure 1973. The learned the divisional magistrate, by an order dated 5/12/2000, declared the possession of the disputed land in favor of the plaintiff. However, subsequently, on being appealed, the said order was set aside, and this court also did not revise the order of the appellate authority, appellate court. It is under such circumstances the suit was filed, seeking declaration of right title and interest over the suit property for permanent injunction restraining the defendants from entering into the suit land or encroaching the suit land. The defendant filed a written statement. The said suit was registered and numbered as title suit number
Second suit 58/2000.
58 of 2020, 2003. The first appellate, the appellant herein, who was the defendant, filed a written statement stating inter alia that the appellant had been in possession of the suit land, and thereupon an agreement was entered into with the vendor of the plaintiff. And at the time of entering into the agreement, the possession of the suit land was handed over to the defendant. The vendor of the plaintiff did not execute the registered deed of sale in favor of the defendant, rather transferred the land by way of a registered deed of sale in favor of the plaintiff. However, the plaintiff was not in a position to could not take possession of the suit land. The claim of the plaintiff, the defendant, is that the defendant is protected under Section 53A of the Transfer of Property Act 1882. On the basis of the pleading, as many as 7 issues were framed. Of which issue number 4 being relevant is as to whether the plaintiff is the owner and in possession of the suit land. During the process of, during the time of, at the time of tendering of evidence, the plaintiff filed an application for seeking amendment of plaint to include the relief for recovery of possession. The said application was rejected by the learned trial court by an order dated 5/5/2004. Inasmuch as the suit was fixed for evidence of the plaintiffs. Thereupon, the suit proceeded and the learned trial court dismissed the suit on the ground dismissed the suit in view of the proviso to Section 34 of the Specific Relief Act 1963. Against that, an appeal was prepared which was registered and numbered as title appeal number 5/2011 by the plaintiff. The learned first appellate court held that the rejection to the amendment application was erroneous, and consequently was of the opinion that the suit is required to be remanded back to the learned trial court to decide, inasmuch as with the remanding of inasmuch as after holding that the rejection of the amendment was illegal, there might be the necessity of adducing further evidence. This order of remand is the impugn order dated 16/10/2015, which have been assailed in the instant proceedings. I've heard Mr. Siladitya, the learned counsel, appearing on behalf of the appellant, inasmuch as he submits that if the impugn order is not interfered with the plaintiff would be filling up the lacuna. He further submitted that the observations so made by the learned first appellate court in deciding the said or in disposing of the appeal would have serious implications and cause great prejudice to the plaintiff, to the defendant in the suit, and more particularly refer to paragraph number 10 to 17 of the appellate order, of the impugned order. None has appeared on behalf of the respondent on call. This court, having taken note of the order passed by the learned first appellate court, which have been impugned in the instant proceedings, is of the opinion that the said order requires no interference. Inasmuch as it is the opinion of this court, inasmuch as a perusal of the written statement filed by the defendant does not mention or raise any preliminary objection as regards the non-compliance to the proviso to section 34 of the Specific Relief Act 1963. It is also the specific case of the plaintiff that during the pendency of the suit, the plaintiff has been dispossessed. And as such, the learned trial court ought not to have rejected the amendment application on the ground that during that the said amendment application was filed at a time when the plaintiff was to submit the plaintiff evidence. This court further takes note of that in view of if the amendment is allowed, there would be requirement of further evidence to be given by either of the parties. And as such, in the opinion of this court, the learned first appellate court was justified in remanding the suit back to the learned trial court by permitting the plaintiff to file the prayer for recovery of possession. Accordingly, this court finds no ground to interfere with the impugned order. Before concluding, this court, however, finds it relevant to observe that the observations made in paragraph number 10 to 17 touches on the merits of the suit, of the list between the plaintiff and the defendant, and the same shall not influence the learned trial court in deciding the suit. This court further vacates the interim order so passed by this court and directs the parties to appear before the learned trial court on the trial court, that is the court of the civil judge.
My lord, now it may change to Amingaon, my lord, Munshi. Because
Earlier it was who?
the Munshi one, my lord.
Court of the civil judge senior division number 3, Kamrup Metro at Guwahati. On 10th of July 2024. Full stop. The registry
Can it be on 15th, my-
on 15th of July. The registry is directed to forthwith transmit the records to the state court, that is the court of the civil judge number 3, senior division number 3, Kamrup Metro at Guwahati, so that the state court is in a position to proceed with the trial in accordance with the observations so made in paragraph number 21 of the impugned order dated 16/10/2015 entitled appeal number 5/2011. Good stop. This court further takes note of that in the instant case, only the defendant of the said suit is being represented. However, the plaintiff is absent. Under such circumstances, the learned trial courts, before proceeding with the suit, shall issue due notice to the plaintiff. Mr. S. Silabekar further submitted that in the meantime, taking into account that the land, where's the land?
Schedule at final.
Azara is here. Azara is in Guwahati. Not necessary. Special messenger. Hey, special messenger.
Number one.
May your lordship. My lord, on your lordship's resolution on order dated 19/3/24. My lord, if your lordship permits me, I have laid down some submissions. From para 7 about eviction.
Mr. Rajchandra, can you come to page 13?
13, ballot, yes.
Paragraph 14.
14.
Yes.
Clause 14.4 of the land policy. Of 2019 gives one category of parameters, which if satisfied, there would be no ejectment in as much as the land policy 2019 being later in point of time. Protects those persons from ejectment who satisfy the precondition prescribed in clause 14.4 of the land policy of 2009. As such, any move to evict any indigenous landless person by the jurisdictional authorities in exercise of power under Rule 18.2 of the Assam Land and Revenue Act 1980 would have to be invariably considered to have been undertaken after subjective satisfaction of absence of the condition enumerated in clause 14.4 of land policy 2009. As otherwise, such a person would qualify for a consideration for the. However, if such a person is not an indigenous landless person, then such person would have a right to have his or her bona fide claim for the land in context adjudicated in the manner elaborated in the case of such and such. Thereafter, the amendment of 1971, 154 and 154A, which excluded the jurisdiction of the civil court. That is at para 15 I have stated. 154, and then 154 has said at page 15, section 154A, also introduced by the said amendment, enjoined that notwithstanding anything contained in any judgment, decree, or order of this court, any notice served or action taken or penalty imposed to any ejectment done under Rule 18 would always be deemed to have been validly done. The said provision also barred the continuation of any suit or proceeding in any court against the government or may I read it, Madam?
Yes, sir.
Good night.
Yes, we are referring to.
Malad, para 17, page 15, Malad. Thereafter, I have stated therein, Malad, taking into consideration, Malad, the concept of proportionality. My whole case is this, Malad. There are two differences. One is the notice for rejectment, and another is, Malad, to give me an opportunity to prove my bona fide. And Malad, 18.2 itself has been put down by the legislature, but saying that if there is a bona fide claim, it will not be affected. It will be not taken care of. Like Malad, the judgment of the division bench in 1983, which I faced with the adoption. Here, Malad, an opportunity should have been given to me. Like Malad, what is a bona fide claim has been discussed in para 13 of that division bench judgment. In that, Malad, if there is a bona fide claim, so 18.2 will not come. Malad, I'm not asking for a notice for eject. I'm asking for an opportunity. What I have stated in my last paragraph, Malad, in page 17. Malad, may I read in the last paragraph? That before an authority takes a summary eviction proceeding, it must consider whether there exists any bona fide claim of right of the possessor of the occupier. The rulemaking authority itself considered that even in such land, there might be bona fide claim of right of the possessor, and accordingly made it a condition that only where there exists no bona fide claim of right, the authority can exercise power under Rule 18.2. Therefore, it is desirable for the authority to consider the nature of the occupier or possessor before taking summary action under Rule 18.2. And that can only happen on an opportunity provided to the occupier or the person. And the opportunity, my lord, it is what type of opportunity? Because civil court is part 154 and 154A. That, my lord, though after 71, the division bench has not considered 154 and 154A. So civil court is part. But what is the bona fide claim? Para 13 has stated. A long time of occupation, structures, and those as we discussed in the division. If that be so, and it is because open against the government, they have allowed us to, one opportunity for us to give us an opportunity for adjudicating or placing our claim as bona fide over the line. That is my case. I am not asking for a notice for ejection. What I want to place through this submission, is that an opportunity provided to us to prove our bona fide claim over the line. And taking into consideration the land policy of 14.4 and even subject to a correction, that's not that much according to law, section 26 of the limitation. If I am more than 30, 40 years, 26 to the limit, if I am based there more than 30 years, at that long duration of possession over the land, at least that can also be described as a bona fide claim on my part. And for that,
But then you have to read it with the article which says that against the state government or the
30 years, my lord. That's what I am saying, my lord. If I am more than 30 years, sometimes some government wasteland or caste land, persons are occupying from 1970 on, 60, 70 onwards, they are occupying. So they should be provided with the opportunity to prove their bona fide. It's not that, my lord, 18.3 and 18.2, there is a distinction. As your lordship lastly held, judiciary cannot go and direct take 18.3 and 18.2 equally. Because 18.3 was separately different types of land where notice for ejection has to be given within, you have to leave it within 15. But 18.2, there is a landholder, proprietor.
What remains in 18.3 now, in view of the amendment brought in 18.2?
Well,
what remains in 18.3? See, 18.2 and 18.3. 18.3 was amended the year 19.
Well,
prior to that, 18.3 was there, 18.2 was. 18.2 at that point of time had only mentioned about those 4 categories of land: and grazing, and roadside land, specifically reserved, and a person who have been already. These are the 4. Well, now they bring it wasteland, heartland. So then, how do you take care of it? Is what remains in 18? In any other case would have it in respect of other things. Here there is no notice, it can be done. It has come redundant because there is no other land left. Is there any conceivable land?
Correct. But 18.3, if I read with rule 23, roadside land, whether for that reason, if somebody is occupying that plot of land, rule 23, they should be given a notice 15 days you leave that plot. Roadside land cannot be settled with somebody else. Rule 23 is there, So if that rule 23 is there, the person who has been there, he has to be removed from that plot of land by giving a 15 days notice. That is why. Because roadside land cannot be settled, if
why do you have to give a notice of?
Because 18.3 says that anybody who is in the other plot of land in the
no, but it is already there in 18.2.
18.2.
Roadside land is already there. And
18.2.
Rule 23, it also says that this particular plot of land, this roadside land, it was earlier at one point of time only 35 meters. Now it has been made 75 meters. Under no circumstances can be settled.
Correct.
So therefore, it was thought about that 18.2 was to the effect that roadside lands cannot be. Grazing grounds cannot be. Specifically, a particular land has been allotted to finance department. That finance department land you cannot take it. If anybody is occupying, you can throw him out. Because the question of settlement to him does not arise. One hand has to understand that there is no question of bona fide claim there.
Yeah, well, a bona fide claim is only with 18.2.
There is no bona fide claim can be there for roadside
Correct, right? That
grazing ground
is rising.
or for the purpose of specifically reserved area,
Is the way.
or when you have been already decreed or passed any order to that effect that look here, you cannot remain out here, then also
No,
you
no,
enter.
My contention, my lord, subject to correction. What I want to place, my lord, in page 8, I have stated there
Mr.
are three parts.
Mr. Rajputri, what my brother is saying, there are two sets of land. One where a settlement can be made under the rules itself, and other is no question at all.
No question.
So therefore, when there is no question at all, no notice is
Notice
required.
in 18.3.
Okay, and therefore two sets of provisions were there. One is notice, other is no notice.
No.
Now, when where notice is required
Well.
is brought into the no notice case, then
Well.
what is the question of keeping 18.3?
My lord, to adjudicate, my lord, here the notice, there in 18.3, the notice was for eject. Here in 18.2, what my contention is this, it is not notice for ejectment. Notice to giving me an opportunity to prove my bona fide. And while the bona fide
So are you saying, Mr. Roy Chaudhary, that a person who cannot be settled in that land, forget about the 97 amendment,
Well.
is required to be given a notice to prove his bona fide claim, whereas a land which could have been otherwise settled
Well.
on the basis of being a cast land or wasteland, there you just give him a notice asking him to remove within 15 days.
My lord, no. My lord, what I want to place that if it is a cast land and a wasteland, is not a roadside land or it is not a land for grazing or other purposes, then if it is only a wasteland and a cast land, where I am in occupation for a long duration of time, I have constructed a structure over there. There, my lord, my bona fide claim is there. If I can read, my lord, para 13, it will also permit me to read para 13.
Okay, are you will go into that? First, tell me what is the bona fide.
That is what I want to place it. Yeah. Para 13, my lord. Para 13 equal or that.
Here it says that it doesn't say much on that bona fide claim. Here it says that a person who has raised the construction and have been residing out there, doesn't give him a 24 hours notice and ask him to vacate it.
My lord,
Para 14.
Para 14, before parting, you would observe that when there are permanent construction, as in the present case, it is highly undesirable to grant the occupier only few hours time to remove the site. It is unbelievable but true that the petitioner was asked to remove his structure and construction RCC within a matter of 24 hours. It was where, in that case, notice was given for 24 hours. It was done knowing fully well that it would be impossible for the petitioner to remove them. Of the judgment, madam. There is a mistaken belief that the authority is competent to eject any person from any government land under Rule 18.2. A person can be evicted under Rule 18.2 from the specific land enumerated therein and not from any and every land belonging to the government or any other authority. The intention of the rule-making authority is in specifying the land used for public purpose or reserved for public purpose have been mentioned, and they do not include trust land or land belonging to the government or the other local authority. The nature and character of land clearly indicate that that court with eviction is called for if a person enters into possession land described in Rule 18.2. My lord,
But when that happens, but that all the other than that corporate, there is a sinister.
my lord, 18.2 is
How do you read it now? Even if we read it now,
when such person has entered possession of a government land or wasteland or estate over which no person has acquired the right of proprietor, landholder, or settlement, or any land that has previously been reserved road or roadside land or for grazing village cattle or other public purpose, or has entered into possession of land from which he has been excluded by general or special orders, when further there is no bona fide claim of the right involved, or and when further there is no bona fide claim of right involved, he may be ejected or ordered to vacate the land forthwith. And the deputy commissioner may sell, confiscate, or destroy any crop there or building construction without authority on the land. My lord, here what I understand, my lord, subject to correction. Here, government land, wasteland, and my lord, the land which have been reserved for road and roadside grazing land or for other public purpose. My lord, now if a wasteland and a cast land is kept open for a quite considerable period, and there is no notice or as such that this is not for any other purpose or for any public.
no, you see, Mr. Chaudhary, on the last occasion, I asked you, I gave you the immediate script. That's for example, we gave you also the script regarding respect of in the Supreme Court and all these courts have been very clear on one aspect that you have a bona fide dispute, which will be similar to a bona fide claim. Then in that regard, you can't resort to summary. Herein also, paragraph 9 of this judgment also categorically states that these summary proceedings are resorted to cases where there cannot be a question of exception. Now you refer to Rule 14.4, to the policy. First of all, the policy cannot be said. Policy is just a expression of the government that we are going to follow in a particular manner. This policy, you may have a promissory estoppel, or on the basis of the policy, you may have created some right or that on which you may claim a promissory estoppel to that effect for the purpose, for which you may have a bona fide. But if you fall within the ambit of the policy, not other.
Not other.
That is one aspect. But otherwise, what is your basis to say that a person can have a bona fide claim?
My lord, my submission before your lordship is this. If a wasteland and a cast land has been kept open for quite a considerable period of time, and no building structures or nothing has come upon from the government side, or no notice has been placed that this will be for such and such purpose, and it is not a roadside land or a village grazing land, then my lord, those land are excluded by 18. My lord, one a wasteland or a cast land.
You cannot say that because of the fact that the amendment was brought in 1997.
My lord, amendment, my lord, here in 18.2, in bracket it has come, government cast or wasteland or estate over which no person has acquired the right of a proprietor, landholder, or settlement holder, or any land that has been previously reserved road or roadside land, or for the grazing.
Remaining, we are not bothered. We are bothered with the first portion of wherein it says about the khas and wasteland.
Government khas or wasteland or estate over any person. Government khas land and wasteland, where my lord, they have said, if I read the whole 18.2, where they cannot throw me out summarily or directly, my lord, when they can, they have to give me an opportunity to prove my bona fide claim that I have a structure over, I have some crops over.
Why?
My lord,
Why?
my lord, here it is said, it has said that, my lord, which he have been excluded of the answer, there is no bona fide claim of right involved, he may be ejected. On when further there is no bona fide claim of right. When there is no bona fide from a government land or caste land, I will be removed when there is no bona fide. My lord, to what is the bona fide claim? It is a subjective opinion that has to be done. Or, my lord, if I can put it that way, 154 and 154A, my lord, they bar against civil court on a notice for ejectment. Notice for ejectment. If I can read, my lord, 154 and 154A, but, my lord, civil court can adjudicate the matter as regards my bona fide claim in a civil court. That can be the other way around of my submission, my lord. If I read, my lord, 154.
No. If you see 154A2, it says about any act done or purported to have been done.
My lord.
So it is also include any act alleged to be done also
My lord.
under that provision.
If I have allegedly without giving me an opportunity for proving my bona fide claim, if it is done, it is illegal, then, my lord, then the civil court can interfere. Every, my lord, act which is illegal is illegal. That can be adjudicated by a civil. Whether an opportunity was for my bona fide claim. My lord, here 154N, my lord, if it reads as such, any matter regarding ejectment of property.
What?
18.2, my lord.
Earlier, what kind of
No.
land,
Wasteland.
wasteland, and those land was already protected PM.
PM. Correct.
But all other including
83. In all other cases, ejection shall be preceded by
what
all other cases, my lord, regarding the roadside land, village.
It is already there in 18.2.
My lord, 18.2 says, my lord, the land which has previously been reserved. Here the word is reserved, my lord.
read it.
Reserved road or roadside land, or for grazing of village cattle or other public purpose. Or other public purpose. My lord, landowner or any land that has previously been reserved road or roadside land, or for grazing or village cattle or other public purpose, or has entered into possession of land from which he has been excluded by general hospital order. So there should be an exclusion order that you will not be allowed to enter this plot of land. My lord, position one. This is after amendment, it has been.
After amendment,
My lord.
but all other
My lord, here, if I, my lord, all other purposes also include roadside land. So your logic says that now a particular plot of land, my lord, when this 4 line has been opened, my lord, there is a from here going from here to now. Previously, there was some places.
one not put on like okay. Here
Other cases.
secure.
My lord, other
What are the other?
my lord, there can be a cases where a government is in requirement of public purpose. government is required. My lord, my lord, here, my lord, it has said, or previously, or reserve road, or roadside, or grazing, or for other public purpose. The word is used, or other public purpose.
No, that is something like giving the land to Mr. Arbor Pujari, Finance Department.
My lord,
That is it. That for Finance Department we are holding it.
my lord.
For this particular ASTC, this particular land is already
My lord,
reserved.
here, if I read it, my lord, this
That
it,
is other level.
Well,
That EFSA, that grazing, roadside, transport, or for any other purpose. That is what my brother is saying, that Mr. Borpujari, Finance Department
Well,
will have a building there.
my lord,
It's highly for a land to reserve for education.
Correct.
It is not.
my lord.
Now, and so there and government with that will not import to
My lord, that is in 97.
therefore 18 says in all other things.
All of it.
So meaning there like other land like western
My lord,
government has
my submission
now
will be,
listen, now government has western and northern.
my lord,
Now what is the relevant education on this?
my lord, my submission will be,
Yes.
after amendment of 1997, government khas land and wasteland was included. Previously, all other posts were there. So, my lord, when 18.3 was there, previously 18.3 was also there, my lord. 18.2,
It is still there.
it's still there. It was there and now it's still there. 97 amendment included khas land and waste. Now, my lord, while discussing 18.3, it means other than the wasteland and khas land, those lands were there in 82, it has been included. Those 4 lands which were there in 18.2 was already there, my lord. There was an ejectment notice under 18.3. Now in 97 amendment included wasteland and khas. Wasteland and khas land, when there is no notice, no public purpose, nothing was there. A man in occupation for more than 30 years, structures there, crops and others there. An opportunity should be given for a bona fide claim or not is there.
We are not there. Registered.
My lord. Your lordship is definitely not.
So
My lord,
therefore, why? Why is we cannot
only
register?
we are here before, my lord, with a legal issue.
It was some good research and the interpretation.
My lord, the legal issue for which we are here before your lordship, whether 18.2 requires a notice or not.
If you go by the state, not good.
My lord, again I am saying,
So-
I am not asking for no notice for ejectment. I am not asking for a notice for ejectment. I am asking for an opportunity to claim, to prove my bona fide.
But you read it down that court.
Because the legislature themselves have said, where there is no bona fide claim for the person, then only 18.2 will be applicable. If there is a bona fide claim, 18.2 will not come into force.
Okay. Now who is going to decide about the bona
My
fide?
lord, I would say, my lord, regarding 154A, 154, it says about that ejectment. It doesn't say about.
No, you say that notice has to be issued for bona fide claim
Not a notice, my lord, or,
as to whether you have a bona fide claim or not.
my lord, that,
So the notice has to be issued.
my lord.
Now, a notice is to be issued, then where do you go?
My lord, it can be for a civil court also
You, on the basis of the notice, you go to the civil court.
to prove my bona fide claim. My lord, because in the civil court or the revenue authority, appropriate.
Then how do you take care of 154A?
My lord, 154 is in 154
A.
A. Before I read, I have to read, my lord, 154 N. My lord, I will read N, then I will read 54 A. N is any matter regarding ejectment of any person from any matter regarding ejectment. The word is ejectment. 154. Ejectment of any person from a land over which no person has acquired the right of a proprietor, landholder, or settlement holder, and disposal of any crop raised or any building or the construction erected without authority on such land. Here, my lord, the whole issue is, or all the issue here is about ejectment. It has not barred a civil court to decide the bona fide. It has not barred for, it has only barred about ejectment. If there is a notice for ejectment, that will be definitely the ejectment for notice without bona fide is bad. And but now 154A. notwithstanding contained in any judgment, decree or order of any court, any notice served or any action taken or any penalty imposed to any ejectment done. Again, the word is here eject. No bona fide.
Then the next one.
Ejectment done under sub-rule such and such of Rule 18 and regulation shall be always be deemed to have been validly done. No suit or proceeding shall be maintained or continued in any court against the government or any person or authority for any act done or purported to have been done under sub-rule 1, 2, 3A, 3B, 4, 5, 5A or rule of settlement rules made under the regulation. Here, my lord, here they say about anything done or eject.
No, it doesn't say. Doesn't say anything about ejectment. It-
My lord,
it
for
is one-
any act purported to have been done under, my lord, if I have to
Even
read,
it includes you being evicted. It includes even asking you to express your bona fide claim. If we
Then,
take
my lord,
your submission also, it would include a notice being given that you are likely to be evicted out here, and then also you cannot go. If we are to construe
Well,
that
then the
if
appropriate
that
authority-
notice is engraved under 152 if that notice is already engraved in 18.2 as per your submission, then
Uh-huh.
civil court bar, if the jurisdiction is barred under one.
well, then the revenue authorities, the options in that judgment was there, it can be the revenue authorities also. Before ejection, the
Therefore, now the question is, once that notice is being given to you, you reply to the revenue.
for that, there is a bona fide claim, please come and assess that. That I have been, even for the bona fide, sorry, my lord, I am testing, it will not doesn't take other. That, my lord, that the duration of my position, the structures that I have made, whether I have made a building with some kind of influence or some kind of permission from somebody or from panchayat or somebody that I have structured as building, whether that has been in a malafide intention or with the bona fide. And taking into harmonious construction, or my lord, sorry for that, my lord, that taken some kind of help from the land policy that has been enumerated, that for the indigenous person, some lands can be settled with them. So, my lord, that is my submission. It's not required for 1822.
No, now let us assume you submit, the revenue authority decides. The revenue authority would be who?
My lord, the deputy commissioner or other person who
Okay.
should bring a notice.
Now, once the deputy commissioner decides that, the deputy commissioner or the circle, the subdivisional magistrate who have been empowered under rule 1.3, 1.3 or 2, rule 3. Rule 3, somebody has been there, given the power now.
Hello.
So, power of the deputy commissioner, delegation 3. Delegation of powers under rule 18.1 and 18.2 is given to the
Delegation of
subdivisional
power to
district officer or the circle officer, yeah.
Right.
So you write it to the circle officer, looking here, they look here, this is my bona fide claim, this is the house.
Right.
Now the circle officer refuses. What happens next?
Well, against that order, I can go for the land of board of revenue. Or
Because
my lord, after that, I can come for the high court. 226.
So then you can go to under 147.
My lord.
To the deputy commissioner.
Deputy, if it is circle officer, deputy commissioner, if it is deputy commissioner, to the board of revenue.
So appeal will lie to the player where that bona fide claim can be decided.
This time.
Now that is okay. So civil court is out.
Ma'am.
Now the next question is, again we are asking, what is a bona fide claim?
My submission will be, my lord, the long duration of time, the structures made with some kind of permission of from any that I have constructing some permission from the panchayat in the rural areas or from wherever I have started a construction, and it has been the construction has been continuing for 20, 30 years. My lord, those crops that I have done over there, whether those things, if placed before the deputy commissioner, it is there. Whether it is a malafide or it's a bona fide. That has
If I am not wrong, the bona fide claim means a claim to remain in possession.
claim to remain in possession
Of
subject
that-
to all those conditions.
No, whatever may be, a claim to remain in possession. if you go by that judgment, this Maria judgment in 2012, 6 SCC, the Supreme Court said, in a suit for recovery of possession, which is based on the recovery of possession where the title is not disputed, you have to show a better right to remain in possession. From that off, the person who is the owner,
Madam,
I think
here
that
the what you want to
we
say, the
can
owner is the
broadly say that can be a bona fide claim.
My lord, here your lordship wants to say the owner of the land is the government.
There's no denial.
Deny. I have to show a better title.
No, I'm not saying about better title. You can't have a better
I
title
cannot have better title.
because the owner is the government.
Government.
So you have to show a better right to remain in possession
My lord,
over
word-
over that land which belongs to the government.
I understand. But here the word used has been the word used by the legislature is a bona fide claim. It's not the bona fide right. It's a bona fide claim. My claim for settlement in relation to 14.4 of 2019. If I have applied for settlement,
No, Mr. Roy Chaudhary, the thing is like this. The civil court cannot adjudicate. If the civil court cannot adjudicate, you are to show your bona fide claim. If you are to show your bona fide claim, you have to show it on the basis of a right to remain in possession of the layer, better right to remain in possession from the government. Now the avenues available to you is once a notice is being given that asking you to do it, you can move very well before the deputy commissioner or the SDC or whoever may be. Thereupon, you can very well file an appeal. But don't you think that you need to prove your better right? You kindly see, you may have a claim that that better right to remain is your bona fide claim.
My lord, only that I think
Otherwise, otherwise, how will they evict? They will have to file a suit where there is already a bar.
they have to file a suit for throwing us out.
Why?
My lord, that
When there is
the-
already a bar,
there is already a bar. That I understand, my lord.
then
My lord, only thing, my lord, my opportunity was
it can't be a one-sided bar. It has to be both sides. So, like you can't go, they can also do. If in respect to an action under 18.2.
Either of you cannot be in it.
so, my lord, for to prove my bona fide claim, my only way, because my lord, if I read regulation 12, then 15, my lord, the government there is the power to make rules for disposal of grant, lease or otherwise of land, my lord, to ejectment of any person who has entered into unauthorized occupation of such land, disposal of any crop and other. The government has made the rules, my lord. And my lord, now in 18.2, there is the condition laid down,
What is 18.6?
18.6. Nothing in sub-rule 3 of this rule shall apply to any person who has refused or offer a settlement in respect of the land of which he is in possession.
Now, so this is again, you can exercise 18.3. You see, kindly see, 18.3 is as it stood. There's no amendment post 1997. 18.3 loses its significance because of the inclusion of the castlands and the wastelands in 18.2. But 18.6 prohibits taking over, exercising the powers under 18.3 in respect to lands where settlement can be given, but he has refused, although he is in possession.
But there is a bar that, my lord, nothing in sub-rule 3 of this rule shall apply to any person who has refused to offer settlement. So no need of giving notice. There is no need of giving notice.
18.6 becomes useless.
What is the relevance of it?
My lord, here, if I have applied, again, my lord, if I apply for settlement,
No, you may not. The reason why you need not apply, you see, when they find out during the settlement operation that you are in possession of the government land,
government,
they may offer you the settlement. Who is in possession, you may be offered the settlement.
my lord,
You
here,
may refuse
he may refuse.
to
But
take the settlement. Then in that regard, they can take action out there, they may give it to somebody else.
my lord, here, if I read rule 15 also, no person shall have a right to settlement merely because he is in occupation of the land not included in the lease. So if I read this one with 18.6, Mala, there it says that I have to offer for my, it cannot be openly given by the government. I have to offer for settlement. The moment I offer for settlement, there also it is a semblance of my bona fide claim that I have offered for settlement. Till you reject it, you don't throw me out. Summary. By long duration of possession, government will not come and offer me settlement. I have to make my offer for settlement.
Now, read regulation 33.
Acceptance or refuse, it shall be in the option of the person to whom a settlement is offered to accept or refuse the. If he is willing to accept it, he shall deliver the settlement officer and acceptance is writing under his hand and the prescribed form. This is my lord, to whom settlement is to be offered, 32 is my.
Yes.
The settlement official shall offer the settlement to such person if he finds to be in possession of the estate, to have a permanent, heritable, and transferable right of use and occupancy in the same, or to be in possession or mortgages of person having such a right. If the settlement officer finds no person in possession as aforesaid, he shall be in his discretion subject to such use as the state government may make under section 12 to offer the settlement to any person he takes. But if
So- 12 permits making of the settlement rules.
Correct.
The offer of settlement which will be made or the permits by which can be given is in terms with section 32(2).
settlement officer find no possession.
But prior to that, he may give a settlement to anybody who is in possession. And this offer of accepts possession, a settlement, can be given. And if you want to accept, you have to sign a document on writing.
So, my lord, if there is a provision of settlement of a land for the government.
Now, therefore, how do you relate 33 with 18.6?
And my lord,
Then you can't throw him out. Kindly see this.
my lord,
You can't, because you have to understand 18.6 came in 1961.
Correct. My lord, here if I
Banerjee hai kitabkhan, some fixation of land.
my lord, if I can say one.
Please.
Here, sub-rule 3 of this rule shall apply to any person. Nothing in sub-rule 3 of the rule shall apply to any person who has refused to offer settlement in respect of a land who is in possession. My lord, here, one thing that if I can place, my lord.
Let us see one thing. Some fixation of land ceiling act. Now, in this case, once the land goes into the ceiling, statement is made under section 7. This particular land now becomes a caste land. It would be offered to whom? Settlement as per
The person who is in possession. The person who is in possession.
who is in possession. Now, if that be so,
Even those those who are landless,
My lord,
so far it is possession, they are tenants under the
subject to the provisions of this act of this chapter in a particular excess land transferred to and vested in the state government of this act shall be at the disposal of the state government. If there is any cultivating tenant, means a tenant under the 71 Act, in occupation of the land acquired from an owner, then he shall be given settlement of such land within a period prescribed in the following conditions. On payment, manner, the state government or the officer empowered by it in this behalf shall entitled to settle any land which has not been disposed of under section 16 in the same manner, in the same manner which is being permissible under 12, as per the rules settled under 12. So, the government or the officer empowered on this behalf for settling on the event shall eject, if necessary, any person in unauthorized occupation.
my lord, permit me
Mm.
to reply on the 18.6. If I can read it, that nothing in sub-rule 3 of this rule shall apply to a person who has refused to offer settlement in respect of a land which is in possession. My lord, settlement cannot be provided for all those land which has been enumerated in 18.3, like, my lord, 18.2 or 8, my lord, if I read that 4 options are there. My lord, implication of my lord, after 97 amendment that when the government wasteland and Khasland has been, my lord, my submission is this: those 4 land other than wasteland and Khasland was prior to it. my lord, there, the 18.3 was also there, it's now also. My lord, those 4 lands includes 18. And now in 18.2, my lord, wasteland and firstland, and here in wasteland and firstland, my right to adjudication for the, my lord, bona fide. My right for adjudication of the bona fide. I cannot be, my lord, if I have a bona fide claim, it's a subjective matter. My long duration of position, my lord, as per if I have applied for settlement, no, man.
Why not? Why not?
Because it is absolutely bar. Roadside bar rule 23 will come. Absolutely bar. But roadside land I cannot be. Only for wasteland and farm.
Then why was this there earlier?
Malad.
They have not removed. They have not segregated out.
They have not taken it out.
From 1931,
Wow.
when the rules came into picture,
Wow.
the bona fide claim was always there.
Always there.
Then why you are saying that it is not there? Just for example, take an example.
That is
Bona
That-
fide claim was in respect of the roadside land, grazing
now,
land everywhere.
by inclusion
So
of
what will be the bona fide claim in that context and now present
my
context?
lord, in the present context, my lord, after the amendment of 97 on inclusion of wasteland and farmland, by impliedly they have taken out, my lord, those 4 property, grazing land, roadside land for public purpose and others. Impliedly they have taken out those 4 of them by inclusion of wasteland and farmland. And wasteland and farmland is
Suppose roadside. Now what government?
my lord, if I am in the occupy of a roadside land, first of all, I cannot claim for my settlement. Neither the government can give me any settlement. And it is a prohibition that it cannot be given. They will give me a 15 days notice to eject. They will say you remove your belongings, whatever it is there, you go ahead.
Is it that
My lord, what I want to place it is this, my lord. On this,
now then why it was incorporated pre-amended? Bona fide was there.
my
Bona
lord,
fide was not.
that is why
Why bona fide was there?
it was there. That is why in 97 the amendment took place, and that's why the government has started to bring in wasteland and farm. And then
What? Why bona fide code was there? I don't have anything except if it is trying to go out of a land which is roadside or so on and so forth.
my lord,
The legislature pre-amended with the word bona fide.
my lord,
Why?
my lord,
What you are-
here, my lord, if I have to read, I have to read as a, if-
15 days I'll have to evict because I don't have.
my lord, if I have to
Then
read,
there cannot be a situation where government has wrongly given a notice to the over a pakka land.
my lord, here, if I have to read, if I, my lord, the 18.2, I will read it as a whole and say that, my lord, if your lordship will see has acquired the such and such, or any land that has previously been reserved road or roadside land. My lord, if before my position of my occupation, it was already reserved for a roadside land or such land.
Is that fair? Government says that it's for roadside.
Well.
It's a roadside.
Well,
The government says roadside.
there is-
That's your argument. This government says it's a roadside land. In 15 days, you have to back it back and
well, there is then the question of bona fide claim will never come if it is a roadside land. There is no question of bona fide claim. My bona fide claim will only come as regards the wasteland or the cast land. If it is a roadside land on an adjudication by the revenue authority. If the revenue authority says, no, this is a roadside land, the question of bona fide claim doesn't come at all. But the only thing is that there should
you
be
don't have a complaint. Government says it's a
roadside land. My lord, if it is roadside land, grazing land, those are prohibited areas. But if it is a wasteland or it is a cast land, not used for any public purpose or other reason, then, my lord, if that be so, then the adjudication of a bona fide claim. Other than those, well, that is why, my lord, the legislature thought of their wisdom that in 97 it be included
it was there.
prior to 97. Right. That was the
maybe
maybe that was the mistake. Maybe they have thought it was in their wisdom.
you cannot presume that legislature has committed
Okay, let us hear the amicus. We'll hear Mr. Roy Chaudhary discuss. Yes. Yes.
Lord, first of all, my lord, whether the requirement of audio alteram partem and notice can be read into rule 2 or not, that I'll address later, my lord. But taking a cue from what your lordship has just said, my lord, the term bona fide claim of right had existed pre-amendment also. So therefore, we must assume that there can be possibly a bona fide right of claim in respect of roadside, public purposes, and also alleged. And now, even in case of vehicle. Now, Lord, I have some reservation regarding the proposition that bona fide claim of right would mean that a rightful claim to remain in possession. Now, this term I had searched for, bona fide claim of right is a phrase used in criminal law to mean as a defense to the prosecution of theft. So someone could be under a mistaken notion that this is my property and he takes it. And therefore, when a prosecution of theft is initiated against him, he can always say, I was under a bona fide belief, maybe a mistaken notion that this is my property or this is not stolen property. Well, drawing the same logic, my lord, perhaps the bona fide claim of right here in the context of 18.2 and 3 would mean that someone who has come into possession, but probably he did not have the mens rea to know that this is government land. And therefore, since he did not have the mens rea or animus curandi, as they call it in the context of bona fide claim of right, therefore he's given a breather of 15 days. Because 18.3 right is not a big right. It is only a 15 days notice where under 18.2, the bulldozers can come overnight. If there is a bona fide claim of right, then a grace period of 15 days is given to him to remove his structure. No, I'll just rely on a compilation of judgments. Now,
So therefore, you want to have that in that context.
yes,
The other right of the natural justice will always be.
will always remain. Will always remain. 18.2, it has to be the requirement of notice, no doubt, has to be read into 18.2, my lord, to see number, because there can be instances where there could be dispute regarding boundary. Supposing a patta land is is neighboring a government land. So to see whether this is actually roadside land or government cast land or land reserved for grazing, there has to be a notice. Likewise, whether he may be perhaps occupying government land, but he did not have the animus. Then also he can plead before the state and say that, look, I did not know because my land is adjoining land. I did not know I have encroached upon government land. So therefore, give me 15 days. But for that 18.2, there has to be an inquiry, and there has to be an inquiry, and at least no matter, maybe not as long as 15 days, which 18.3 is saying, maybe even shorter, but at least that person has to be put to notice insofar as 18.2 is concerned. Now, 18.3, my lord, 18.3 would come. That is the reason why it says in all other cases, meaning that even if you have a bona fide claim of right, you do not have a right to remain in possession. At best, you are entitled to the benefit of 18.3. That's all. So therefore, my lord, 18.2, that inquiry has to be there. That inquiry can be fourfold. If I've understood whether it is actually government wasteland, whether it is actually roadways land, whether it is actually grazing land. And lastly, and because the wordings are and further, he does not have a bona fide claim of right. He had no reason to not know that this is government land, and he did not have the animus to sort of encroach upon government. Now, if the inquiry regarding whether it is a government land or khas land, if that is decided otherwise, my lord, then yes. Now, my lord, then, my lord, we have to fall back on the full bench decision of Daulatram Lakhani, because I believe to decide bona fide claim of right, or a bona fide claim, let us forget bona fide claim of right, my lord, to decide on a bona fide claim, the civil court will not have jurisdiction because Dolotram Lakhani says the only way to get out of the trappings of 154 is if you establish title. And title again has been explained in Dolotram Lakhani that it has to be title, it cannot be a husk of title. So to say that the civil court would have now jurisdiction to also decide bona fide claim will be a little far-fetched on the face of 154. Now, one thing which I wanted to address at the outset was, my lord has already seen the judgments, my lord. 76, this particular rule was struck down as ultra-vires in the case of Bandana Goala. Now, the reasoning that was offered, my lord, of course, it would be sort of traveling beyond the scope of reference, my lord, but I just wanted to point out, Bandana Goala said that 18 is bad because we are drawing among the same class of encroachers, we are drawing two different classes. One where the government sues by way of a regular suit, and the other is a very summary remedy under 18. So therefore, 18 was struck down. Now they wanted to cure it by introducing 154N. Now 154N was incorporated on 28/10/1977. 71. Now, my lord, by this time, 71, my lord. Now, by this time, the 1976 Public Premises Act also came. 2010, again, the Land Grabbing Act came, and Land Grabbing Act, interestingly, also includes government land, my lord. So, does it now mean that since with the coming of the 2010 Act, we are back to the position of 71 where the government again has two remedies? My first judgment, if your lordship sees, this is the case of Bandana Goala, my lord. Para 5, 6, 7, and 8. This was realized.
But Mr. Dekar, what you are saying,
Yes.
in the concept of Rule 18,
Alright.
it means that if it is a case wherein there is a person comes out there and says that I didn't know that this was government, and as such, if it's a roadside land, I didn't know the roadside land, and the government then takes. However, in respect of other land, then a 15 days notice. The word is in other cases.
In other,
18.3 does not say anything about bona fide.
you know.
How do you gel your arguments for that aspect, for that
My
concept?
lord, I've understood. My lord is basically indicating in all other cases, would it cover only cases of where there is a bona fide claim of right, or also in cases where it is held?
Because in you go by Bandana Goala case also,
Alright.
the court have all along understood that Rule 18 is a special power given for the purpose of throwing out encroachers from government.
Yes.
And this has been all along followed till date with the reference. As of now, we still understand that the Rule 18, although whatever you have submitted looks very, seems to be also a very well thought proposition. But Rule 18 seems to be a proposition wherein it has all along held that power is there of the government to throw it. If it is in the government hand, it has been all along. And the reason why Vandana Gola came is that, look here, you have a power for the purpose of taking over, exciting somebody to the civil court. And this is a summary power. You can't have two powers.
Exactly.
Following that Sarkar judgment
Yes,
of the state of West Bengal and now Northern Indian Cataracts.
Yes.
And it says these double remedy, if it is done in Article 14 value. I think that
Yeah,
must be
that's
the
the
reason.
purpose.
So if all along the courts have held it or thought about the concept of Rule 18 to be stuck, would that be a case of stare decisions? Taking into account all along, yes, whatever you submit, I think this should have been the interpretation all along. And why this provision is not brought into the regulation is also another very disturbing thing, because a power to take over somebody's land or somebody's right should be the substantive power which should have been there in the regulation, not by the rules.
Right, right.
Here, a rule has been permitted to be made by which a person can be thrown out, and this is how it has happened, and it has been all along construed in this manner. Now, if that be so, how do you, I mean,
My lord, in fact, my lord, that is something that had troubled me at page 6, my lord, 2015 judgment, which again examined Bandana Gwala. So, this is Bhanumati Ghosh.
Yeah.
Page
Page 15.
Page 6 of that compilation, my lord.
Okay.
Page numbers on the top,
Yeah.
top right. This is Bhanumati Ghosh, my lord.
Yeah. But
Now here, if your lordship skips over to para 19, page 10, my lord. With the insertion of 154(1)(n) and section 154(a) by the amendment of 1971, the defect and infirmity found by this court in Bandana Goel while holding Rule 18 to be ultra vires was cured, notwithstanding the ouster of jurisdiction, Daulat Lakhani. So 2015, my lord, by a single bench, it was held that with the introduction of 154(n), this vice of there being dual remedies is gone, my lord. But what was perhaps not pointed out, by this time, the 2010 Land Grabbing Act had come. And Land Grabbing Act again gives them the power, no matter summarily.
And in fact, that act has been primarily made for government land.
For government. For government. So
And
then we are back to square one where there are two remedies. Again, they're creating a class among classes. Of course, I would have suggested, my lord, that the Assam Public Premises Act of 1971 was also another remedy. But the division bench has held otherwise. It has said that it will not apply to government land. But let us assume that Public Premises Act is not applicable. 2010 again the land grabbing came. So basically we are in a position where the government can now again pick and choose. For some encroachers, they can resort to the lengthier remedy of the land grabbing. And for someone, they can go for a court with eviction under 18(2). This was what was precisely sought to be remedied by Bandana Gwala. I know, and which is why my yes, which is why I said it beyond 18(2). Yes, true. To that again, my lord, I'll say that Rupjuti's case, my lord, that was perhaps concerning Silsako. It was held that 18(3) notice, 18(2), since 18(3) specifically provides for a notice, the requirement of notice cannot be read into 18(2). This was the reasoning behind holding. Yes. Yes, exactly. Now, I was suggesting, my lord, a group duties case where it said no notice is required because the requirement is only under 3, and if you fall under 2, no notice is required. That is. But what I would say, that notice under 18.3 perhaps will come later.
Go by those.
And that has to be a notice of show cause rather than a notice under 18. That is what I'm suggesting. Now, if we say that to exactly. Yeah, exactly.
So we say that no notice.
We said
Okay,
no notice.
But what about the
Yes, exactly. That's what I'm saying, my lord. 18.2 will require a notice because since you are deciding by implication, it will require a notice, and that is why I have another the next another judgment. Well, even if they decide it's okay, man. But here there is no scope of decision at all. Even if the but then again audio alter imperative would come.
That's why we are asking.
Yes.
So who decided?
Without hearing him. And the problem is post-decisional hearing is also not contemplated because of 154A. So neither is there a pre-hearing nor a post-decisional hearing. So it is totally bad. Yes. Yes. So therefore, my lord, that under reasoning which was offered in Roop Juti's case, that 18.3 requirement of notice cannot be 18.2, that was in the context of a notice for that breeder of 15 days. What notice would actually be necessary for 18.2 is rather a notice of show cause, where we decide bona fide a claim of right, or whether it is government or caste land. So notwithstanding that 18.3 notice may not be applicable eventually. Yes. Notice. No, show cause notice. Maybe it is not as long. Bona fide claim. Precisely.
Now what remains of 18.3 in view of the incorporation of caste lands within 18.2?
Which is why I said about the meaning of the word bona fide claim of right. Lord will have that judgment. No, inquiry. Yes. Required. Yeah.
No, then how do you take care of what remains of 18.3? Why I'm saying of 18.3 is 18.3 says about the notice of 15 days.
Yes. Yes.
Now, you see, the problem arose because of this. 97 amendment was brought in, by which a thing which could not have been settled. Now, lands which can be settled is also brought in. So, you may have a, just for example, in a case where it is a government land, the government says that this is a roadside land. He may have a bona fide claim to the effect prior to that. That look here, this is not a roadside land.
I'm beyond 66.
I'm beyond this the 75 or whatever may be. I'm beyond 75. And as such, or just for example, half part of it may be in the roadside, half may not. He may have a bona fide right and as such. Then in that case, it could have been, that could have been a bona fide claim. Now at that point of time, 154 1N was not there. And 154A was also not there. Yes, it can be seen that in order to come up with that aspect, they have now come up with this 154N and 154A. So therefore, it is not there. And now we are not still, we keep the question open as to whether it would still be in violation of Article 14, taking into account the Land Grabbing Act. That is another question. for a far-sighted writ petition to be filed by you at a later point of time. But as of now, 18.3 doesn't survive. And if a better notice is given under 18.2 or the requirement of 18.2 is much more, then what remains of 18.3?
18.
Does 18.3 remain in view of 18.2, which now, as per your submission, in view of the audio alterum partem rule, you have to give a better notice?
Lord, I look at it this way, my lord. 18.2 inquiry, my lord, will be, that inquiry will be a broad inquiry. Now, ultimately, if it is held, it's roadside, it's government, it's grazing, then also, even if it is held to be roadside grazing or government, my lord, despite that, if I at least prove bona fide right of claim, then I'm entitled to that 14 days notice. I fall in all other cases in 18.3. Now, taking the example of what your lordship had said, that supposing a person claims that this roadside land, I'm beyond 66 feet or 75 feet. So this is my patta land. Now, perhaps for that,
No, that's a wasteland. I'm saying now, earlier,
earlier, prior,
it's a wasteland.
Yeah.
Or half of it, you are asking me to make it entire thing.
Yeah.
Half of it, half
Half
of it
is
is wasteland and half of it is patta. My
Wasteland.
wasteland, where I
and
can
we
use
are
it.
before 97.
I'm a landless.
Man,
And we are before 97.
97. And secondly, another aspect. A person, just for example, Mr. P.K. Roy Chaudhary, his client, was a resident of that particular area prior to 97. Now Castland has been brought in.
Yeah.
How do you take care of that? That he may have a right which accrued prior to the act coming into force. That might be a bona fide claim.
Because at that time he knew when he entered into that he knew
That
that
it,
after that settled in very
and 18.2 doesn't cover Castland.
now he's on
Well, then perhaps again 15 will trouble him, and only way to get rid of that would be regulation 6, the last, because rights of landholder also includes the rights derived under section 27. Section 6, if your lordship sees, regulation 6. So that right is recognized.
Mr. Barbujari, like we are now having these 3 criminal laws as it is outdated on the basis that somebody was saying on a discussion and regarding the criminal laws out there, you still have a particular provision which was there in the Indian Penal Code that a person in India, if he makes a conspiracy to kill somebody in Goa, then there's no problem with that because Goa was outside India. That illustration of Indian Penal Code still continued till late, till I think will be there till 30th of June. Now here you see the rights acquired under 26 and 27 of the Indian Limitation Act 1887. Don't you think that these needs to be done by your government something?
True. But for the purpose of this requirement, I will be limiting my argument on it.
No, I'm saying that
Yes,
because
correct.
this is in reference to 26 and 27 of the Indian Limitation Act 1877.
Yes.
We are in 1963. Tell me. The 26 and 27 of the Limitation Act 1877 is parameter to 26, 27 of this. So a person who acquires the right acquired under 26 and 7 of the IMAT
Will be a right recognized under the regulation. There is another difficulty here again, my lord. If we seek to reconcile. Now, 27 is saying if a person doesn't sue for possession within the 12 years, then that right extinguishes under 27. But here again, to reconcile it would be difficult because the government cannot sue in view of 154N again, or 154 again.
And
Not there. But this is the regulation and that's the. Yeah.
but
Not there.
Alright.
Let me
or section 27 of the limit. Yes, what does it say?
At the determination of the period hereby limited to any person for instituting a suit for possession of any property who has right to such property shall be extinguished.
Who's right?
Government under 100, Article 100.
But 100 governments would be not 12 years, 30 years.
30 years. 30 years.
So government's right would be 30 years,
At the expiry of,
provided he claims
provided he claims.
adverse.
Edward.
That is only, that will, he has to prove his adverse.
Yes, true. No, I was referring to that example where he's occupying wasteland. And then if he shows that by virtue of his long possession, it has ripened to title and then he can go to the suit and 154 will not be a bar, considering the ratio laid down in dollar terms.
But the only, there is no bar to filing a suit for recovery.
Yes.
There's no limitation.
Yes.
No limitation. They can file at any point of time based on title.
Yes. That would of course depend on fact situation.
Then if that be so, whenever he claims adverse, then in that case, against the state, it will be 30 years.
Yes.
Are you saying when he claims adverse, he becomes and 30 years is over, then this 6C will come into play?
Yes. Should it not?
Then after that, when he wins the case in a suit,
Then he goes.
and if he doesn't file a suit, unless he files a
files
suit,
it. Then he files.
anything else?
Regarding that issue of notice, my lord, if I next the judgment at page 37, my lord. So the recent judgment, my lord, that all the authorities were discussed. Okay. Page 37 of the compilation, my lord. State Bank of India versus Rajesh Agarwal. Just few paragraphs, my lord. Para 36 first, my lord. Here it has basically discussed all the authorities and it said then when the rules are silent, then rules of natural justice have to be read into. The same thing. And until and unless it's excluded, yes. And mere use of the word forthwith, because there was one argument in place that this is an urgent resort that is taken. So therefore, we can do away with natural justice. So here also 18.2 says forthwith eviction. Now, relying on Swadeshi cotton mills, it was held that that is of no consequence unless you show that there is an express waiver of the rule of audio alterum partem. Now, naturally, they are deciding it is bound to have civil consequences. There's no larger civil consequences than rendering a person homeless. So, given that position, my lord, 18.2, maybe it will not have a 15-day long notice. It could be 3-4 days, but there has to be an inquiry. And maybe they decide, my lord. Maybe they as revenue authorities decide, my lord. And supposing it is not just a bona fide claim of right, but is even a superior right as concerning a right of title, then the remedy is open because of Dolaram Lakhani full bench judgment. So long as it's not merely a husk of title.
What does Dolaram Lakhani say?
Dolaram Lakhani, my lord, annexes the last judgment at page 106. Your my lord, 154A and the case of Bandana Gwala was taken note of. And eventually they drew a few guidelines at para 22, my lord. Para 22, if your lordship. This is the summary of. When the order.
This is on the premises of that Dhulabai, no?
Yes, yes, yes,
Where Dhulabai's case says that when the jurisdiction under Section 9 is not barred,
yes, yes, yes.
if it is beyond the jurisdiction of the authority and all
Authority.
these things.
And so provided there are complicated questions of title. But what worries is it says when the order under Rule 18 is patently illegal. my lord. Now, if 18.2 doesn't contemplate a notice, there may not be an order as such for them for the person concerned to institute this suit going by 22.
But 18.2, does it conceptualize it,
No,
an order?
no order.
Or does it say that about an order to be passed on the basis of which the action is to be resorted?
No, it doesn't say nothing. It says nothing. Some determination. And which is why I relied on it.
They will have to take at least 2 things.
Yeah.
They will have
No, bona fide.
they will have to
Yes. And if we go by the Supreme Court, now bona fide claim of right is a defense. Now, how do you decide on the existence of a defense without putting that person to notice, my lord? It's a right of defense.
Here the use word is he may be ejected or ordered to vacate the land forthwith.
Forthwith.
So ordered. So ordered means maybe an order being passed.
Which is why I'm saying it should comply with natural justice and it has to be communicated to me at least. Going by Rajesh Agarwal's case. It's a long judgment, my lord. All Olga Tellis also have been dealt with. Because Olga Tellis also, there was one power with the commissioner. They said it must, since there's a word may, you will not necessarily infer that you may do without notice. So that is what.
And if the rule has come in the year 1931,
Yes.
there is no amendment to 18.2 till 97.
97.
97 does not take anything, but it has never been put as to requirement of audio alterum partem aspect,
Yes.
have not been dealt with by any of the judgment.
Except one where because or 102.
18.1 here.
This was. My Lord, Justice A.P. Singh had probably said much.
No, because the principles of natural justice encompasses many aspects.
Yes.
It will first require a notice.
Yes.
May not be a long standing hearing, thereby asking he may reply or he may not reply.
Yes.
There in the
Tahir Ali
compilation.
says no notice.
Principles of natural justice, since my lord, we are in a welfare state, this is what, this is the winter. Generally, lordship will find. Yes,
Yes,
in
yes.
my compilation, lordship will find it, my lord, at page 54. Yes, I will. Yes,
So the first aspect is as regards the notice as to whether he has a bona fide claim or not. Or
Right.
just to evict, he may have raised a bona fide claim, which will require an adjudication.
Yes.
Adjudication includes an information to him,
Yes.
which is also a part of natural justice.
Natural justice. All facets. But only thing is, we will be countered with the judgments which have already been passed, which is, I think, Rupjuti Bora Borgohai, my lord. That's one. Then there is Monica Bora, and there is this Kundargaon in anti-eviction committee. All of which they've said in that. But
What are
those,
these?
No, my lord, getting two judgments for which judgment? 2006 one DLR page 9. May.
yes. Because
My lord,
Timaldas.
in
Now,
which your lordship was
this.
No, it's okay. Rupjuti Buragoy is okay. Don't worry.
other judgment of your lord.
No, Rupjuti Borla is one. Rupjuti Buragoy is a case of water bodies.
water body.
Water bodies, there is a complete bar of doing anything. See, there is a therefore, not only don't go into Rule 18, you can very well invoke the Water Bodies Act itself.
Yes.
Although there were many arguments out there that their right had accrued prior to the enactment of the Act. That is another aspect of the matter. But that does not prima facie or primarily deal with Rule 18 in that regard. But with the Water Bodies Act, only a person can be truthful. Then comes which one? Tahir Ali.
Lord Ishaq Ali, that's the division bench judgment.
Which one?
Ishaq Ali. Ishaq Ali is page 17 of the compilation submitted by the state.
Page 17.
Like by Rajiv Kaur, by state, page 7.
No, Ishaq Ali is a case where you see there were various other litigations.
I think, my lord, Roop Duty para 43 is what is a little.
Only see Ishaq Ali, page 19.
Yeah.
Para 7.67.
The recourse for eviction is the correct mechanism, and the Public Premises Act is not attracted.
No. Para 7.7, page 19.
Yes. As the concerned government land is earmarked for the Office of the Labour Commissioner, the recourse to summary procedure for
So it is specifically assigned to a particular place. Can you appreciate that? We are therefore not to take into account that this land is for earmarked for something, which will come within those original four.
totally. Yeah. Both. No bonus.
Paragraph 18.
And also we have been inducted by constructing structures and are receiving rental income there. Yes, that's on fact. Yeah, commercial.
You see, this is not a land which is required for them. We have to see also the land policy.
Yes.
If it is the requirement of the person who is a landless indigenous person, who requires this land for his right to live,
Sustenance.
because right to shelter is also a right to life.
Yes.
So under such circumstances, if it is so, can it be? But he's here, in this case, this person was using it for other
Commercial.
purpose. And the question of odi alteram partem,
Yes.
is how the authority will decide the bona fide claim, I think is not being dealt with any of the judgments.
In any of the judgments. And in fact, my lord, where they are discussing notices, my lord, the notices are, they are only concentrating on a notice about sub-rule 3. If your lordship sees,
They see the petitioner's counsel's submission out there,
Yeah.
in this case, he submitted that, look here, these are not true, these boundaries are wrong and all something to that effect. Kindly stay here. What does
in
he say?
Ishaq Ali, my lord,
Ishaq Ali.
Yeah,
Since
Ishaq
the
Ali.
concerned area is not reserved for roadside areas, submits that the eviction cannot be ordered under 18(2). These type of submissions are being made.
now
That is
only
the problem.
page
That is
15,
why
page 51, if your lordship sees, that was the other judgment. Yeah. In
you are referring to which para, page 51.
page 51, 43, my lord.
Yes.
Now this is concentrating on the notice under rule 3, not the notice which is required for to satisfy the principle of odi alteram partem. My lord, a bare perusal of sub-rule 2 and sub-rule 3 of 18 makes a clear. Page 51 of the compilation submitted by the state. This is Rook Duty's case, my lord. 43. A bare perusal of sub-rule 2 and sub-rule 3 of 18 makes a clear distinction regarding the nature of the encroachment, whereas under sub-rule 2, specific mention has been made of government khas land, wetland of state over which no person has acquired the right of proprietor, landholder, settlement holder and land reserve land, roadside land, grazing land or other public purposes, and eviction can be carried out. Subsection 3, however, lays down for any other class of land, before eviction notice is necessary. This court is of the opinion that when the language of the statute is plain and free from any ambiguity, where no other interpretation is possible, the golden rule of interpretation is to give a plain and literary meaning to the statute. Further, the wires of 18.2 is not questioned in any of the so-and-so. Then para 43, under the facts and circumstances, the court is of the opinion that when the language of the statute itself is clear and there is distinction between eviction under 18.2 vis-a-vis 18.3, the requirement of issuing notice under 18.2 cannot be read into while interpreting such. Now, it seems, Malad, the focus is on whether the 14-day notice requirement can be read into 18. Whether the notice of, for the purpose of fulfilling natural justice can be read into 18.2 or not, that is not the consideration here.
In fact, this recently I got hold of that 1931 statement. What you initially submitted for the bona fide seems to be actually what has happened. But none of the courts or anybody has took it in that manner. And that is why you have Vandanagol.
Yeah.
Every other case, it's all happening because it has always been construed that the revenue authority has the power to evict. Now, the thing is like this. If 18.3, as I said, conceptualizes a notice only for the purpose of giving you 15 to get out. Nothing else.
Nothing.
You just go away 15 days, I am giving you. Earlier, no time, but here I am giving. Now, does 18.3 has any value? Or wouldn't that be arbitrary on the face of it in view of 18.2? Then under what circumstances 18.3 comes into picture? There's nothing else. Or if we say that if it is a case of bona fide claim, then 15 days, you can be asked. That means, again, it violates all the ultimate part.
So at best, in the best of the cases, my lord, going by that logic, in the best of the cases, or at best, what you are entitled is a breather of 15 days. That's how it pans out.
Even if you have a bona fide
Bona
claim.
fide claim. That
Even if you say,
you dealt with. My lord, just para, the page 31 of that judgment, my lord. Of course, it's a judgment passed on the criminal side, my lord. Page 31. Yes, of my compilation, my lord. In fact, two judgments back to back. They are dealing with bona fide claim of right. I tried to search with the direct. These are the two Supreme Court judgments are found, my lord. Para 6 and 7 at page 33. This is, of course, a narrower meaning, my lord. In this case, my lord, he has to admit that I am occupying government land, but I did not know. So therefore, don't penalize me with an eviction force. Exactly, exactly. And there are cases, my lord, where checklist has been forwarded by the circle office to the land advisory committee, and at that moment, my lord, the notice 18.2 is initiated. That, and once he loses possession, my lord, then again the land policy will not give him that benefit.
so Mr. Deka, your submission, first submission, although seems to be good, but we are not going. As regards the submission pertaining to the coming into effect of the land grabbing and that would not be
That'll be
proper
too
for us.
much given
That
the
is
scope
too
of reference.
far for this matter. But overall, your submission is there is a requirement of a notice in view of the fact that the
There
it
will be
being a facet of Article 14, natural justice principle, natural being an asset, which is always to be taken note of. And any provision, and the State Bank of Judgment also said, even it is mentioned as forfeit, then also it is implied. A notice may not be for a long period of 15 days, it may be a 7 days notice also, or 3 days or 4 days notice asking them to give a reply. And with a reply, there is a decision which needs to be communicated. Till there, I think that is your submission.
And last, my lord, taking up
And
your
the other judgments which have been referred to out here by the state, although deals with many aspects of it, but the aspect of bona fide claim have never been dealt with by any. Yeah.
And
Anything last?
lastly, my lord, going by Bandhana Goala, my lord, what your lordship has just indicated, that is another, maybe we can call it a vice, my lord. Bandhana Goala basically said that Article 14 should apply equally, my lord. So you cannot create a class within a class. Now, going by the land policy and the set rules which your lordship had just referred, this is again creating a class within a class in the sense that some two persons occupying government land as encroachers, to one they are benefiting the extending the benefit of settlement, and to the other they are resorting to a stringent or a drastic summary proceeding for eviction. So that is also perhaps
How do we read down? You are an American. He may not say in the petition. He may the respondent. He may not say. You are the friend of the court. Tell us, how do we integrate this principle into Rule 18?
not when the rule is under challenge. That's
That is the problem.
otherwise I would have advanced arguments on that.
There's no
Where
problem.
is
Then otherwise, my lord, we could have gone to Bandhana Goala and your lordship could have said that that vice which was noticed in Bandhana Goala has resurfaced with the coming of the land grabbing act.
Only therefore
Notice. And further.
Another thing is the question of
Proportion.
Now, this aspect, why I'm saying, don't you think that your submission on Bandanagwala, which you just made, can be brought within the purview of proportionality, principle of proportionality, wherein it is the requirement of the state or the administrative, when an administrative action is taken, they are to see that the stringent, they take
Dominant.
such steps which the least effective. So thereby, can't we bring that concept within the concept of proportionality? Have you got that judgment?
Yes, my lord. I think Sanjay Kishan Paul had very succinctly laid down in that Aadhaar case also properly.
Other case is there. Yes. And
Aadhaar case,
also,
Sanjay
I
Kishan
think in
Paul's
that,
Justice Paul's concurring judgment has dealt extensively with the doctrine of proportionality. But then again, my lord, again, the rule not being under challenge.
no, not necessary. Because you see,
Yes.
Rule 18, you see, it's an administrative action. Further, earlier it was not much, but with the recent time, the doctrine of proportionality has been construed to be a facet of Article 14. If that be so, can't that principle which you are saying that be brought within it as to why they could not? Maybe they may have to record your reason. And when the writ or any proceedings is filed, they have to produce, yes, this is the reason we want to throw him, and not the question is not there, but this. Because we need a particular infrastructure at this particular place, which is good for us, for which we are taking up this action. They may record the reasons in their files, which may be a concept of proportionality.
True. And more so after
Because there might be a case that, yes, Mr. Abach's place is there, which is in a place which is very conducive for a particular market environment and all. But Mr. S. Doctor's place is somewhere out of the line in the hills and all. There's no electricity. We don't want that. We take his land. And this is necessary because we are having a particular this flyover nearby, and out there we are going to connect it. They may have the reasons. So if these reasons are contained when a challenge is made, they can very well place it.
So there has to be a valid.
That would be the proportionality aspect where they will record the reason, they will keep it. So this is the reason why we have adopted this 18, not gone for any other land grabbing act.
Correct. The report can look into it. Yes. Report. Yes. That's one way to. Yeah. That's right. Yeah.
That is why the first order we make on the question of proposal. This is how you bring in. Because if you see the judgment of media one,
Yeah.
it was an administrative act. The Supreme Court engraved the principle of proportionality. Then why was it necessary for you to take up this? Isn't this the most drastic of the actions you have taken? Couldn't you have taken a lesser action than this? And if that be so, you have to record your reasons when there is a challenge being made. You may have a good reason that we needed this. We are not taking up the land grabbing or any other method because we need it urgently.
Until 97, it was perhaps fine. With the inclusion of baseline,
That is the problem. Hello. Matter being heard. Yes, Mr. Barbuzari. When? Yours. You are complete. You are complete.
if you lot to.
No, you give your note and
If
we'll
I
hear
think
you.
of anything, if I
Yes,
can
on the
come up with some-
proportionality
yeah,
anything
I'll
further.
address it.
Mr. Roy Chaudhary also. Just speak. Yes, Mr. Barbuzari, when?
Two 2019 policy is in existence. It is in force now. There. Because then my lord, that facet of public interest. It is not. Yes, yes. Other policies also. Definitely. And if a person becomes eligible under such policy, say for example, my lord, there are policies of our own department, the department whom I am representing, rehabilitation policies, riot affected persons, flood affected persons, they are settled, they are allotted land. That those things are done in pursuance of my lord larger public interest. And in all the eviction cases, Rossi will find solitary, one or two exceptional, I will not comment on that. All evictions are done in public interest. It is not. Yes. All evictions are done. Record it. Another aspect is that you are having a policy. So if they will report, whatever is for I will not, or it can be a policy of yes, yes, that policy is still there. But what yes, now what the petitioners are harping is that, my lord, that
I am in possession. Suppose, my lord, I am an enforcer. I term myself as it's a government plot of land. I come into occupation of that plot of land. The government makes an exercise to evict me. I resist that eviction process, maybe by filing of a writ petition under 226. And I say, my lord, that I am entitled to settlement over there. That is not the policy. Government says that you will be entitled. You go somewhere else in the state of Assam. Yes, yes, yes.
How will you say it? Or you will say that, no, whatever you say,
No, that is always open. But in all the cases, most of the cases, yes.
where you say that they are affected by that, yeah, it is to some state. That is a reason. So therefore, you have to say things that you will not be affected by the land. That is also
That will my lord bring up under the provisions of the rules. I will try to satisfy my lord. Whether the rules permit. Because bona fide claim of
No, no,
right,
Mr. Borbujali, we make it very clear. Whether the rule permits or not, the rule has to mandate as per Article 14. I make it very clear to you. Don't be on an assumption that you can make a submission or whatever may be. Make it very clear. It has to follow the mandate of Article 14. We are going to do that. But the only thing is, how do you do it? The question is, he may be entitled to. You see, what my brother was saying out here, that as you have said, the public interest. The public interest is also takes care of the question of proportionality. That you have a larger public interest which requires you to take over the land. That is the public interest. So that is the requirement which requires to be brought in. That's all. Now, as regards whether you have a better right, whether he has a bona fide claim or not, you can very well adjudicate. But how will you know that whether he has or not, or whether he is going to raise or not? That is the question.
that I will disclose my lord in my argument.
Yeah. So that, we make it very clear to you. So don't say about that rule. Rule is prehistoric or archaic rule, which needs to be interpreted, read down in a proper manner.
I will try to my lord
We may
circumscribe my argument within the fourfold of.
We have a
What?
we have a
I will try to
in absence
circumscribe
of
my
challenge,
argument.
in absence to challenge
I
the rule,
Yes.
we are not going to touch the matter. But we are in a position that we are not our down.
And challenge was made to the rule that was negated.
How does it matter?
I will try to, my lord, because since I am representing
In
the
a public interest litigation.
Yes.
Challenge in a public litigation, there are plethora of judgments of the Supreme Court wherein says that a public interest litigation judgment is never a res judicata. Any judgment. In fact, that day I was going through a provision of the Evidence Act. Interestingly, the Evidence Act, the provision was saying when an admission made by a person, swing in the representative capacity is not an admission. From there, therefore, from there you can go to that judgments in respect to public interest litigations. Anybody, any person, if he says makes any statements in a representative capacity, that cannot be taken as an admission for that entire group or anybody, other group who may come with it and thereby foreclose the rights of others. Anyways, when
38th of May, my lord.
no, what 30th, too long. We'll have it on early. Third,
Yes, the holiday. 23rd is a holiday.
28th.
28, yes, 28.
Is the matter. We have heard Mr. K. Roy Chaudhary, the learned counsel, appearing on behalf of the petition. Mr. B.D. Decker, the learned counsel, appearing on behalf of the learned amicus. However, the hearing remained incomplete inasmuch as the state of Assam is yet to be heard. List the on 28/5/2024 for further hearing.